We've been meeting since September on this, and we are here now with the -24s. And I wanted to remind everybody a little bit about our shared goals. We know that we have to take action. We've got 5 Oregonians are overdosing and dying every day. We have a goal to get people into treatment and recovery and not jail. And we agree that the current system, the way it is set up, is not working. And we need to give providers and law enforcement the tools that they need to keep people safe and save lives. And we have heard from Oregonians across the state, and we have incorporated their feedback into this plan. We've heard from over 100 people at the last hearing. We have over 2,000 pieces of written testimony. Public input has been critical to every step of the way. We have heard hours of raw, honest, vulnerable testimony right here in this room, and I gather we are going to hear that again tonight. And I want to thank everybody for being here and giving us that testimony. It is incredibly important. We want to make sure, of course, that everybody understands sort of the many public health goals that we have with this plan, and then I was going to turn it over to Representative Krupp to go over some of the public safety goals. We know we have to urgently expand substance use and mental health treatment in the state of Oregon. We know we have to urgently increase prevention. And we know that we have to prioritize those things. So I believe the budget proposals are now posted on OLIS. I encourage you all to take a look at those materials and take a look at the investments. These investments prioritize increasing access to treatment with shovel-ready projects. They prioritize behavioral health workforce because we know we can't open them up without making sure that we have the workforce to do so. We prioritize prevention. We have a youth strategic plan for behavioral health that we are going to need to give attention to in the 25 session. And we're giving local communities the tools they need to build a bridge between law enforcement and treatment providers, including deflection programs, where both sides of the system need to be working together. And I think that is really, really important, and something that was important from day one when this committee was put together. But I want to say that this bill is really the start of a transformative changes in our justice system. It's treatment first. It's a blueprint for reducing harm and improving outcomes for everyone who interacts with the justice system, not just for drug-related issues. We're building out a different way of doing things, and a different way is hard. It takes buy-in, and we have 23 counties who've said that they want to have deflection programs. 23 counties representing over 80% of our population.
A plan that gives law enforcement people to treatment as quickly as possible. With this bill, we are staying true to our intention to reimagine a justice system for this type of situation with a rehabilitative lens, to try to help and maximize the number of people that we can move from crisis to stability. In this framework, we've created multiple off-ramps from the criminal justice system into treatment. Waiving fines and fees, which can be a barrier to people expunging their record, and sending a clear signal to our district attorneys and to our courts that jail is a last resort. We want to motivate and incentivize and help people get the help and treatment that they need. I'm appreciative that 23 counties have stepped up to implement a deflection program. We're creating flexibility so those counties can create programs that work for what's happening in their town and works within the resources that they have. On the state level, we will be partnering with those communities. We'll be providing oversight and funding to help those counties be as successful as possible, with report backs to the state so that we can figure out what's working in Bend and what's working in Portland and what's working in Salem and what should be the best practices and what should be the standards as we continue to build out deflection programs. With this commitment from 23 counties, we will be covering 85% of the state's population. We are making sure that when people take the steps to engage in treatment and to take corrective actions, that will be acknowledged. And the cleanest way we're going to do that is to make sure that their record is expunged as quickly as possible. We know that many people have the ability to expunge their records and don't because our system is complicated. We ask people to file their own petitions with the court to expunge their record. That is not the approach we're going to take with this unclassified misdemeanor. And if you're unsuccessful with deflection and a court-based diversion and on your probation, and a judge eventually does revoke your probation and sentence you to jail time, that you still have the opportunity to be released from jail to participate in either inpatient treatment or be out in your community and participating in outpatient treatment. These are significant steps forward. This is not the way we used to do things in the state of Oregon. Like I said, we are trying to get people from crisis to stability and set up a system here in the state that helps do that. Additionally, we are providing clarity to our drug delivery laws so that our law enforcement and our DAs have the tools they need to prosecute people who are profiting off the addiction of others. With the combination of the investments we're making to expand access to treatment and services, we are making improvements in our system, both our behavioral health system and our criminal justice system. Thank you so much for being here today. I appreciate all the time and effort so many people have provided for this process. When I look at the entirety of this package that we're putting forward, it's a reminder to me that we started this process by saying no one person had all the answers to this. And there are bits and pieces in this package that come from the conversations we've had from folks from law enforcement to behavioral health to folks who have their own lived experience and folks who live in all four corners of the state. We are going to be taking steps forward so that we can have the type of system that makes immediate connection and immediate engagement for folks into services and the treatment that they need. With that, I'm going to call up Legislative Counsel. Jessica and Lori, are you here to walk us through the -24 amendments? Are you? All right. What?
You want to do Jessica Menifee?
Is Jessica's presentation able to be uploaded right now? Great. Do you mind, Lori, if we switch the order? Great, thank you. Jessica, welcome. I see how many amendments are posted. I can't imagine how much work you've had to do in the last few weeks. Thank you.
Co-chairs, members of the committee, Jessica Menifee from Legislative Counsel. I'm just going to review relatively quickly the changes in the -24 amendments, basically the differences between the -24s and the -1s. So these first two slides are just a very quick overview of provisions that are remaining either the same or are very similar to the -1s. So the change to the definition of delivery to include attempted transfers, in other words, the state v. Boyd, meaning that's not changed. The enhanced crime categories for certain types of delivery in certain locations, The only change there is that in the Dash 1s, the delivery had to occur within the park, and in the Dash 24s, it would be within 30 feet of the park. And the reevaluation of release guidelines by the Chief Justice for delivery and manufacture is unchanged. These next three provisions, again, the welfare hold expansion is not changed, the data tracking, no substantive changes, and the Class E violation provisions are being repealed with the adoption of this new unclassified misdemeanor. The big change here is that these changes will become operative on September 1st, 2024. So these next few slides are the main differences between the amendments. There is no longer, there is no longer a defense to a charge of possession if you complete a deflection program. The amendments instead encourage both law enforcement agencies and district attorneys to deflect and divert these cases. And the idea is that if a law enforcement agency adopts this deflection program, these cases would never reach the point where they would be charged. The Oregon Criminal Justice Commission will be establishing a data tracking system to collect information from deflection programs that do start up around the state. And you can see that there's a couple of goalposts here, 12 months after the effective date. And again, this bill would have an emergency clause, so it becomes effective when the governor signs it. The Criminal Justice Commission will conduct a study to determine best practices and standards for these programs, and then at 18 months, they will actually adopt these standards and best practices for deflection programs. So currently, the conduct that is described on this slide is a Class E violation, and all of these would become what is called in the amendment a drug enforcement misdemeanor, and this is all beginning on September 1st, 2024. So a drug enforcement misdemeanor is just a name given to what this new misdemeanor is. And for all intents and purposes, it's an unclassified misdemeanor in that it doesn't fit within any of the current categorizations of misdemeanors with their maximum penalties. The penalty for a drug enforcement misdemeanor is either a straight time sentence of 180 days if the defendant requests and the court agrees, or a period of 18 months probation, supervised probation. And any jail would have to be suspended. So the court could not impose a sentence of jail at sentencing unless they're doing that straight time sentence with the defendant's consent. So there would be an 18-month probation period. While the person is on probation, the person would be subject to structured sanctions that could include jail time for violating the probation. It could include things like community service. If the person is ultimately revoked from their probation, the court could impose up to 180 days as a revocation sanction. And while that person is serving that 180 days revocation sanction, the person would be eligible for early release to treatment. And the county community corrections agencies, so usually county parole and probation, would be tasked with monitoring the availability of these treatment programs to see if the person is eligible. And if the person is eligible, there's a treatment program available, the person would be required to execute a release agreement in order to be released early to the treatment program. And while they're subject to this release agreement, they could be required to abide by certain conditions as outlined by the corrections agency. And for this new type of misdemeanor, there could be no fines or fees ordered as a provision of the sentence. These parts of the new possession charge are unchanged from the Dash 1 Class C misdemeanor provisions. Basically, these will be considered a designated drug-related misdemeanor for purposes of supervision, duty, and funding. The provisions for the new type of conditional discharge are very similar to what's in the Dash 1s. Basically, this is a pre-plea type of probation where the person can enter in a probation agreement, and if they fulfill the terms of that agreement, the charge would be dismissed against them. The main changes here, as you can see, are in the Dash 1s, the defendant was automatically eligible. Here, the district attorney can object based on certain grounds, and then the court will decide if the person can enter the agreement. And there was some clarification as to what happens with other charges the person might be facing. And there was some ambiguity under current law as to whether someone could be subject to days in jail if they violate the terms of this type of probation. So this adds a provision that these people can be sanctioned up to 30 days in jail, both on this type of conditional discharge and conditional discharge that exists under current law for drug crimes. The expungement provisions are very similar to what was in the -1s. The main change is that upon successful completion of probation, whether it be conditional discharge or probation after conviction, there would be an automatic expungement. That is the third bullet point there. But you can see that the timelines are relatively similar. The Oregon Behavioral Health Grant Program is still in the amendment. The type of applicant is somewhat changed. It's a county or a designee of a county or a tribal government or designee. There's a certain type of cooperation and coordination that needs to occur before the applicant can apply for a grant for a deflection program. And there are certain partners to the deflection program that must be part of that coordination, and the application has to show that coordination. And the coordinator, in a previous version, it had to be coordinated by a community mental health program or local mental health authority, and that's been changed to coordinated by or in consultation with. And I would just also point out that a couple of the other more stringent requirements for the grant program have been removed as well. And then there are some new provisions at the end of the bill that come from House Bill 4120. This is another grant program for jail-based treatment for opioid use disorder. And with that, I'm available for questions, or if someone wants to reach out after the hearing, because I think we have a lot of testimony to receive. Either is fine.
I'll take a few questions. Senator Przansky.
Thank you, Mr. Co-Chair. Jessica, when you were going through the slides, you were talking about the conditional discharge, and if I heard you correctly, you stated that there could be basis for the district attorney to object to someone going into the program. Could you please elaborate as to what type of basis, what they could be objecting to? I was under the impression that this was going to be a straight exit ramp out of the system, but it sounds like there's discretion with the district attorney's office.
Co-Chair Senator Przansky, the district attorney can object. The basis of the objection would be if entry into the probation agreement would not serve the needs of the person or the protection and welfare of the community. And then the court would hear the basis of the objection and ultimately make the decision.
Follow up.
Yes, please.
So what I'm hearing is that the district attorney or a deputy district attorney is going to tell the court why someone shouldn't go into the program based on not fitting the needs of that person. I'm not sure what qualifications the district attorney or their deputies would have to make that determination as someone not in their best interest.
Is that a question, Senator?
I'm just trying to figure out if that's what that means, is that
Co-Chair Senator Przansky, again, the district attorney would need to make an argument based on those factors. I suspect the argument would be along the lines of this person has already done this program several times and didn't successfully complete it, something along those lines. Ultimately, it would be up to the judge to decide.
Thank you.
Representative Nose.
Thank you, Chair. My question is two parts. I think it's a little bit along the lines of Senator
serving a revocation sentence of the 180 or up to 180 days. If there is not a treatment program available for early release, they wouldn't be early released. If there was a program and they were released into the program and then they, left the program or stopped absconded or something like that, then they could be returned to jail to serve the remainder of that 180 days.
So can I?
Unless
maybe
you
I
can
can
answer
help.
my question. Go
Sure.
ahead.
So if you're on probation and you're ordered to do certain things like treatment, you can only be violated if you willfully violate that. So if there's not a treatment program for you to enter into, that would not be a willful violation.
Okay.
If there's a treatment program that you're able to access and you don't go or don't engage, that potentially is a willful violation of probation.
Follow with you?
Sure, Jessica, sure.
Okay. So I'm going to kind of use a slightly extreme example. I'm a person that's been living on the street for an extended period of time, all right? I used in public. I'm going to make an assumption about that person probably having a lot of challenges, might have difficulty getting to their appointment, might not have a car, transportation. Like, I guess what I'm asking is there a judge or somebody that gets to use a little bit of discretion? Like, yeah, Representative knows you've been living on the street for 5 years. You missed a couple of your appointments. That's not flaming out versus maybe me actively not going. You see what I'm trying to hear if there's any discretion.
Well, there's always judicial discretion with the court. And if you have a probation officer, there's also a probation officer has discretion about
Okay.
how they're working with you. Members, any other questions? Jessica, thank you very much. Are we ready for Lori?
Co-chairs Lieber and Krupp, members of the committee, Lori Freeman from the Office of Legislative Counsel. And I'm here to talk about the changes to the -1 amendments, the behavioral health provisions in the -1 amendments made by the -24. With respect to the prohibition on utilization review by insurers for coverage of SUD medications, that is the same, except it provides exceptions to the prohibition for auditing claims for improper payments, fraud, or abuse, or for reasonable periodic redeterminations about the continuing need for care. It also allows the coverage to be subject to other terms and conditions that apply to those benefits. There were no substantive changes to the requirements for CCOs to provide medications for opioid use disorder and any co-occurring SUD or mental health condition. The prohibition on CCOs and public payers requiring prior authorization for medication-assisted treatment were modified to limit the medications to those approved by the FDA on or before January 1st, 2024, and to allow CCOs to require prior authorization for a brand name drug if a generic equivalent is available. The dispensing of refills by pharmacists, now they can prescribe and dispense medications and refills under specified conditions. And before, the State Board of Pharmacy in adopting rules was required to appoint a Rules Advisory Committee. Instead, they now just must consult with the Public Health and Pharmacy Advisory Formulary Committee. There were no changes to Section 8 that allow a retail drug outlet to have a prescription drug locker on site. We deleted the section that just clarified existing law that prohibited group recovery homes from discriminating against a tenant based on the tenant's involvement in medication-assisted treatment. There were no changes to the provisions requiring CCOs to have adequate networks of addiction treatment providers. And there were a number of changes, or there was one change to the Alcohol Drug Policy Commission, and that was to require the commission to focus their study on opioid use disorder treatment instead of substance use disorder treatment broadly. And then the only substantive changes to the provisions regarding certified community behavioral health clinics was it required OHA to begin preparing a draft state plan amendment by January 15th, 2025, the -1 amendments required them to submit the plan by that date. And it also removes the date certain for when OHA has to seek federal financial participation for the costs of the program. It's now tied to the expiration of the demonstration program. With respect to the Joint Task Force on Regional Behavioral Health Accountability, it added a bunch of new members. First, there were 2 members appointed by legislative leadership, one from each party. And then we added someone appointed by the Chief Justice to represent Judicial Department, and then a number of other members here that I probably don't want to use up valuable testimony time to go through. And then finally, it changed the date of the draft recommendations from November 15th, 2024 to September 15th, 2025. And the final report from December 15th, 2024 to December 15th, 2025. It creates an all-new task force on improving the safety of behavioral health workers. This was a provision that was part of Senate Bill 1594A. It also creates a new United We Heal Medicaid payment program to provide supplemental payments to behavioral health providers so that they can access enhanced apprenticeships and training programs.
Great. Thank you, Lori. Any questions for Lori? Lori, thank you so much for being
Sure.
here. Thank you for all your work. Next, we'll hear from Ken and Kelly from the Criminal Justice Commission about the racial impact statement. Welcome.
Thank you. Co-chairs Lieber and Krupp. For the record, my name is Ken Sanchgren, and I am the Director of the Oregon Criminal Justice Commission. I'm here with my colleague Kelly, who's going to introduce herself so that we can kind of jump back and forth as needed.
Yeah. Good evening, Kelly Officer, Research Director at the Criminal Justice Commission.
So just a little bit of background. On Thursday afternoon, we received 2 requests, actually, from 4 members of this committee for racial and ethnic impact statement pursuant to ORS 137-683. We completed that statement as of today. We submitted it around 3 o'clock, and it's been posted to OLIS. And we're here to provide the background on how we arrived at our estimates and to answer any questions that you may have. So in a very basic sense, we, as we've gone through this process, have been preparing both for the fiscal impact statement, because we do the bed impact analyses for all criminal justice bills, but then also in the back of our minds, we knew that this might be an eventuality too. And so we relied on that fiscal analysis work that we've been doing over the past few months as the underlying components to what we put forth today. And so I'm going to turn it over to our research director, Ms. Officer, to talk about the fiscal impact estimate so you can have an idea of how we got to our numbers, and then I'll go on and talk about the disparity analyses that we conducted.
Thank you. Yeah, so I'll go ahead and get started. As Ken described, we worked from that sentencing impact estimate in the deflection program. Now, this is a new thing. It hasn't existed previously, so this is probably the most challenging part of compiling this estimate. We were able to look at information in 2019. As you know, anything previous to that, Measure 110 and COVID has impacted those. So we went back to 2019 as the starting place and looked at all arrests across the state with a possession of a controlled substance or PCS charge. Many of those arrests, about 65%, had another crime on the arrest event. So we did remove those because if there's other criminal activity, we're assuming those would not be eligible for deflection. We also removed arrests where the person was on active supervision. So that person's already engaged in supervision. And so we removed those as well. And so that gave our statewide estimate of a deflection eligible population. We received the information that there are 23 counties that are ready to move quickly to implement a deflection program. So assuming those 23 counties are able to get that program up and running by September 1st, that's our starting point of folks that would engage in the deflection program. From there, we had to assume, who's going to be successful. And again, these are new. They're likely going to vary somewhat by county. And so we are assuming that 50% of individuals that engage in deflection will be successful in that. We've seen that with other criminal justice programs, about that 50% success rate. We also have information from our impacts program of high utilizers of behavioral health and criminal justice resources, that about 50% of folks in impacts programs are engaged 3 months in. And so we use that as a starting point of the estimate. Now, obviously, if more counties are able to implement deflection programs, or if that success rate is higher, right, we will see more folks that successfully complete deflection, or if there are hurdles along the way and not all counties are able to get there, or the requirements to be successful are something more than we're thinking today, then that's going to change things too. So that deflection estimate is I think probably the toughest part of the estimate that we put together for you. So from there, for folks that are either not offered deflection or are not successful with deflection, we're assuming those folks will have a PCS conviction. And then also folks that have other crimes, other misdemeanor crimes on that arrest event, we're assuming those folks would also have a conviction. So that gives us the estimate of folks that have this conviction for a drug enforcement misdemeanor. So we have that estimate. And then finally, for the delivery changes, we were also able to look at 2018 and 2019 data of delivery sentencing trends in informing that analysis. So we have the Boyd deliveries that we're able to look at in that time period. And then also the enhancement for delivery that occurs a certain distance or in a treatment facility, temporary residence shelter, or public park. And so the closest proxy we were able to use for that is the enhancement currently for delivery within 1,000 feet of a school. So we're able to use that data to then estimate the impact of those enhancements as well. And I'll turn it back over to Ken.
So using those base numbers from 2019, we then took the racial distributions for those different groups as we saw them in 2019, and then applied them forward to our estimates that we are providing to you today. Again, believing that was the best proxy to move forward with. We utilized a disparity tool called the raw differential representation, which is a step beyond what you would normally see in disparity research that looks at risk ratios or other population-based estimates. It's still population-based in that it actually has risk ratios involved as you calculate. But what it allows us to do is it actually allows us to see the number of folks who would be impacted by a given policy decision. So the results that I'll be talking about today will talk about the number of folks we believe from different racial groups will be convicted or sentenced or other outcomes. But then we'll be able to talk about how either under or overrepresented folks are. And we can actually identify the number of individuals we would either need to divert from the system or otherwise treat to make sure that we could have parity with our reference group, which were, for the purposes of this discussion, our reference group are the outcomes for white Oregonians under this new law. And so the primary takeaways that we have is that, at least with regards to possession of controlled substances, when we're looking at just those convictions for those folks that, as Kelly mentioned, have either not received a deflection offer or who have not succeeded in deflection or otherwise enter into the system, we are estimating that approximately 2,200 individuals will be added in to the system compared to what we see today. And what we have found is that when we break that down by racial groups and look at the raw differential representation, the only group for which we see there is a disparity is for African American or Black Oregonians. And what we see is that of those 2,200 additional convictions, we would estimate that 103 of those would be for Black or African American Oregonians, and that if we wanted to have parity with white individuals, at least based on census shares, we would need to see only 73 convictions. So the difference between that 103, and 74, 29 is the gap that we were identifying in our work. And what we wanted to do in the impact statement too is to try to provide a little bit of context as to where the system has been and where we sit today. And so we did at least provide some additional information on some research that we've done in the past after some of the initial reforms to possession were passed in 2017. that, pre-2017 and House Bill 2355, we would see an average conviction disparity of around 150. So you could compare that to 29, which is what we're predicting now. And so the system does look different today than it did even before those reform efforts began. With regards to convictions for delivery, that is a much smaller number overall. We are predicting between the convictions for delivery and then also the enhancements that Kelly mentioned, 111 additional convictions per year. The majority of those, around 70, would be the classic Boyd level 4 convictions. The remainder would be a bit higher on the grid, depending on some of the enhancements that were discussed in the bill. Of those 111 additional convictions, we estimate that 7 will be for Black or African American individuals, which again is the one place where we saw a disparity for that outcome. And of those 7, 7 is what we would predict for there to be parity. There would need to be 3. So the gap there is 4 convictions over what we would think based on census share. We also have some breakouts on things such as sentence length or conditional discharges, but I think that we'll pause there to see if the committee has questions on kind of the primary takeaways we identified in our draft.
Thank you. Members, any questions?
Mr. Chair?
Yeah. Representative Mannix?
Thank you, Chair Krupp. So Co-Chair Krupp and I were the ones who signed off on requesting a report, which I did read this afternoon. So even though I missed the start of your presentation, I'm aware of it, and I thank you for that. This is a generic question. For each drug trafficker taken off the streets, how many lives will be saved? We don't know that, do we?
Chair Krupp, Chair Lieber, Representative Mannix, we do not know. And I think that we've tried to take care to identify disparities. It does not, I think as we say in most of our disparity research, it does not really indicate, the value judgment of those.
Follow up on that?
Yep, you can have one follow-up, Representative.
One follow-up. So it seems to me there would also be a disproportionate impact on African Americans whose lives might be saved if we interdict those who are purveying hard drugs on the streets.
Co-chairs Krupp and Lieber, Representative Mannix, I believe that could be the case. We stated that this committee has heard that there have been disproportionate impacts on those communities, yes.
Thank you. No further questions.
Senator Steiner?
Thank you, Mr. Chair. One of the clarifications I would like to ask is your disproportionate impact has to do with the success rate, it has to do with people who succeed in deflection or diversion. Do we know whether there are evidence-based approaches to increase the likelihood that people from historically disadvantaged communities, whether those are people of color or other disadvantaged communities, can be more supported to make it more likely that they succeed, which would thereby reduce the disproportionate impact? Because I know there's a lot of emphasis on this, on culturally appropriate deflection and diversion programs. So I'm curious whether you have any evidence about that or information.
Senator Steiner, co-chairs Lieber and Krupp. I don't have academic literature to cite for you here, but I think that's something that we were thinking through when we were building this as well, that, fidelity to both the legal requirements that are being proposed in the -24 and then also ensuring that there's equal access is going to be key. And I think that would be key to the accuracy of our predictions as well.
Yeah, and just to be clear, not just equal access, but access to appropriate and supportive services that reduce barriers to successful completion of the treatment, I think is critically important to address some of these disparities. Thank you, Mr. Chair.
Welcome.
Chair Krupp.
Yep, Representative Balderrama?
Thank you. Thank you so much for putting this together and for those who asked for this report. It's been very informative. I have a couple of questions. I'll start with the information on the Latinx community, predominantly on page 7, regarding the Boyd deliveries and the disproportionate impact, which I read as the number of convictions, right, of those 111 additional convictions. There is a disparity you mentioned by both Black and African Americans and Latinx individuals, individuals comprising about 25.5% of those imprisoned. and that this percentage does show a disproportionate impact or disproportionate number of Latinx individuals imprisoned as compared to the population, and the average sentence in length and in months does show that the other groups have a shorter imprisonment sentence by almost 3 months. And so the way that I read these two paragraphs essentially is that Latinx are serving prison sentences disproportionately, and they're also serving disproportionately longer sentences. Can you help clarify some of this data and why that hasn't been mentioned?
Sure, I'll go ahead and take a stab at that one. Yeah, so we do see that the longer average sentence length for prison sentences for drug delivery for Latinx individuals of about 3 months. And we do also see when we look at the total prison impact that we would expect from the delivery changes, it's a total of 31 prison beds. And then when we calculate that disparity measure that Ken described, that does result in additional 4 Latinx individuals imprisoned for delivery convictions. So we do see that disparity measure there on the prison impact for those 4 individuals.
Thank you, Chair. And then for the some of the data that you mentioned earlier around Black and African American communities of the additional convictions, predominantly disproportionate impacts on the PCS charges. Can you share a little bit? Is that essentially the number of folks who are not completing deflection, right? So the point, I guess, of the -24, right, of the conviction is a non-completion of deflection. Can you clarify a little bit there what that data reflects?
Sure. Representative Valderrama, co-chairs. For that, we do have to make some presumptions as to successful completion. And at this time, we don't have much else to go on other than to assume that they'll be completing at similar rates across the different racial groups. And so I think that's why the comments by Senator Steiner were essential earlier, that for this model to work, we have to ensure that we can have successful completion cutting across all groups. That's what we are presuming.
Yeah, I'd just like to know that the data is really helpful, and I am very concerned about a lot of the disproportionate impacts that you all have found and have stated in the report. So thank you very much for the information.
Thank you. Members, any other questions? Director Sandringham and Kelly Officer, thank you for being here.
Thank you.
Members, I forgot to gavel in the public hearing on House Bill 4002, so I'm going to gavel that in at this point. So we are opening the public hearing on House Bill 4002. The testimony that we've already heard from Lori Freeman and Jessica Menifee and Ken Sandringham and Kelly Officer will be considered part of the public hearing for 4002.
No.
First folks that we have coming to testify will be Mary Mamet, Rick Treleven, and Heather Jeffries. Mary, Rick, and Heather, are you here?
Yes.
Great.
Yes.
Yes.
Perfect. Mary, do you want to start us off, please?
Yes. Co-chairs Lieber and Krupp, members of the committee. For the record, I'm Mary Monette, CEO of LifeWorks Northwest, a nonprofit providing mental health and addiction services to over 20,000 Oregonians each year. I'm here today to testify in support of Section 13 of the bill, focused on Certified Community Behavioral Health Clinics, CCBHCs for short. First, thank you for the legislature's previous support of Oregon's CCBHC federal demonstration project. As one of only 8 states to embark on this innovative pilot in 2017, you helped pave the way and can be proud of Oregon's leading edge. LifeWorks Northwest operates 4 CCBHC clinics in the metro area, and bar none, this pilot has been the biggest game changer in providing more coordinated, effective behavioral health care in my 40 years in the field. And trust me, I've seen many pilots. This one deserves to soar. With CCBHCs, we were able to design and cost out a more complete model of team-based care that integrates mental health and addiction services with additional physical health screening and monitoring and robust care coordination, truly providing holistic care for mind, body, and spirit. This approach is so needed given that those living with a behavioral health illness die 25 years early due to other often untreated chronic health conditions. For the first time, we had outreach, peer wellness, and culturally responsive supports to better engage and support our consumers. And we did. Pre-pandemic, we improved access to care by 25%, effectively eliminating waiting lists with same-day access, and we reduced our consumers' use of emergency rooms. The new reimbursement model allowed us to increase wages and reduce staff turnover. We were just hitting our stride when COVID hit, and we are finally regaining steam. Going forward, CCBHCs offer hope for all of us in keeping our consumers safe and stable in the community. At a time when we desperately need a dramatic increase in access to behavioral health treatment, this program provides a sustainable, federally funded model that allows us to do that efficiently. To be clear, this is not a new program. The effort of this bill is to codify the current program into statute to ensure that if the federal demonstration ends, the program does not end in Oregon. Thank you for your recognition that Section 13 is a part of the critically needed infrastructure to expand access to behavioral health treatment in Oregon at a time we so desperately need it.
Thank you, Mary. Rick?
Thank you, Co-Chair Lieber and Croft, members of the committee. For the record, I'm Rick Trelevin, CEO of Best Care Treatment Services, a nonprofit delivering behavioral health care in Central Oregon and Southern Oregon. I'm here today to support the first 5 sections of HB 4002-24 amendment. These are sections that make it easier to prescribe life-saving medications for the treatment of substance use disorder. Same-day access to the full range of FDA-approved medications for addiction medicine has become critical in reducing the deaths from overdose. The opioid epidemic has morphed from being prescription drugs to being heroin to being fentanyl to now being fentanyl plus. Prescription drug benefit strategies that made some sense when we had a prescription drug problem are now fatally flawed, literally fatally flawed with fentanyl. We don't have time clinically when people come in. We need to be able to provide same-day access to these medications for folks. And so there is no time for prior authorization process. And so what we're trying to do in this bill is many of the payers have already stepped up to the plate to remove these barriers, provide rapid access. And what this bill seeks to do is to hold all payers to the same standard of immediate access that saves lives dramatically and in the here and now. So really want to support the amendments as written in the bill right now. Thank you very much.
Thank you, Rick.
Thank you, Co-Chairs Leeper and Krupp, members of the committee. For the record, I'm Heather Jeffress. I'm the Executive Director of the Oregon Council for Behavioral Health. And as you know, our members are likely in your community with over 70 member agencies across the state of Oregon. I'm here today in support of 4002 sections 11, 12, 16, 17, and 81 through 89. These sections, as mentioned by the previous speakers, are sections that really focus on obstacles to providers that are in this part of our systemic structures and practices, and really obstacles that make it hard for them to really scale services at a statewide level to the capacity that we need. So we really appreciate the time and energy that this committee has taken and in your previous work to remove these barriers that may seem very policy and procedural, but are excruciatingly important for the success of the system of care and for getting equitable access to all Oregonians. I've attempted to highlight some specific examples out of these various sections. One is exploring alternatives to the buy and bill agreements, and also, as Mr. Trelevin mentioned, medication-assisted treatments. Particularly, buy and bill has some big impacts for remote and rural small providers with small populations that they're serving. Also, we are extremely excited about the Youth SUD Service Capacity Statewide Focus Study Group. We're very excited to support that and to be part of that ADPC discussion. Really, in the last 15 years, Oregon has had a dramatic loss in capacity, and we would like to understand that better as we start to rebuild a system of care for youth. We also are grateful to Senator Lieber regarding Section 16 and 17, Regional Behavioral Health Accountability as Oregon Providers Network. We are really here and we hear your frustrations, and we really hope that the historical context of where we're at as the state, that we can continue to move forward with these innovations to do better and continue the focus. And with that, I have submitted the rest of my testimony in writing in my 2 minutes. So the other section that we're super supportive is sections 81 and 89. Thank you, Representative March, for ensuring access to medications in correctional facilities and taking a look at the CCO structure and how it can be better leveraged to support the behavioral health network.
Great. Thank you, Heather. Next panel we have is Grant Hartley, Jennifer Parrish Taylor, and Maylee Browning. We're going to pause for just like 2 seconds. We want to make sure we got the timer wasn't quite working correctly, so just give us a minute. Oh, timer is working correctly. There we go. Working. 5 seconds. Who would like to start?
I'll go ahead and start.
Great.
Co-chairs Lieber and Cruff and members of the committee, for the record, my name is Jennifer Parrish Taylor, and I'm the Director of Advocacy and Public Policy with the Urban League of Portland, one of the oldest civil rights organizations in the state. I respectfully submit this testimony in opposition to House Bill 4002 with the -24 amendments and all amendments recently submitted. At the start of this process to repeal Measure 110, Black and brown communities were told explicitly by lawmakers that recriminalization would happen, that the legislature had to end the session with a bill, and that if they didn't figure this out, we would face a ballot measure that would be far worse. Despite our fears, our community turned out in droves to lay bare our traumas, our fears, and warn of the immediate and future violence this policy would have on our communities. To say that we refuse to be a part of the process is patently untrue. We lobbied hard and reaffirmed that the theoreticals of this policy, when put into practice, would have real and lasting implications for a population that is overly represented in the worst possible ways when it comes to homelessness and criminalization. And with each conversation and response, it was clear that our warnings and data had not been heeded, let alone considered. Because of their absence, I can only think that legislators either don't believe Black and brown communities, or worse, they just don't care. With HB 4002, Democratic leadership and Republican proponents of the ballot measure, using the tools of white supremacy, have succeeded in building a slightly larger cage for those who will be collateral of the criminal provisions of House Bill 4002, which will cause unconscionable harm and lasting violence to communities of color and other Oregonians experiencing drug addiction. The racial impact statement, which comes too late in this process, still shows that there will be negative, disparate impacts for Black Oregonians. I ask that those legislators listening who believe in racial justice to vote their conscience at this moment. Let me be clear. This bill will pass without your votes. I appreciate the acute political pressures you are under not to break with leadership on this issue, but the time is always right to do what is morally right, even when it feels hard. We urge you not to pass House Bill 4002 and all related amendments.
Thank you, Jennifer.
Good evening, Co-Chair Lieber, Co-Chair Croft, members of the committee. My name is Grant Hartley. I'm the director of the Multnomah County Office for Metropolitan Public Defenders. As a public defender, I represent some of Oregon's most vulnerable and oppressed citizens, people who have been continually had their voices silenced as they cry out for help, and once again, those voices have been silenced in this process. You've been provided data and research showing that recriminalization will only exacerbate the addiction crisis in our communities. And not only will it fail in achieving its purported goal, but it will also deepen the racial disparities that are rampant in our criminal system and continue the failed policies of a war on drug, a war which has caused so much harm in communities of color that it has become synonymous with racism. But those concerns have been ignored and the voices raising them silenced. I do not wish to be unfair to the legislators in this body. Many of you want to do the right thing, but find yourself in a difficult position. Mr. Williams, Mr. Barton, and the millionaires and billionaires who support them have waged a public war of misinformation since the inception of Measure 110, culminating with a ballot measure to repeal Measure 110, which they are using as a threat against this body in order to control this democratic process. Conceding to that threat sets a very dangerous precedent. And the bill that has resulted is truly concerning. I have heard this bill described as a treatment first process, heard legislators say that people will get into treatment before, rather than jail in this proposal, and that is simply not accurate. In reality, most people will be brought to jail when they are arrested. They will likely not receive a public defender for the foreseeable future. If they do get one and want conditional discharge, they will be denied the basic due process rights, like the ability to see all the evidence against them and to file a motion when their constitutional rights are violated. They will be placed onto probation, where they can be jailed for 30 days, before being placed on another probation where they can be jailed for another 30 days, before being revoked and sentenced to 180 days minus whatever they served on probation. This will create a dangerous revolving door with individuals going in and out of treatment, each time increasing the risk of overdose and disrupting any semblance of stability they had in the community. And for what? To try to compel them into treatment that does not exist. Before we punish people for not engaging in treatment, we must ensure treatment is actually available. It is not, and this bill does not change that sad reality. Thank you.
Thank you. And I was told Grant was going to use a little bit of your time. Either way.
He's done.
Go ahead.
Thanks. Hi, everyone. My name is Maylee Browning. I'm the Legislative Director for the Oregon Criminal Defense Lawyers Association. I'm going to do a little bit of a deep dive into conditional discharge. Like the good senator mentioned, the -24 has new language allowing a DA to object to someone entering conditional discharge, and a court may decide to let the person in or deny the person entry based on what's in the what's best for the person and for the community. That language is really vague, and there's no parameters on that. And we expect that to lead to some unequal enforcement throughout the state. For example, we expect probably the Washington County DA's office to object to every single person entering conditional discharge who has tried at treatment before and were quote unquote not successful. Another issue regarding conditional discharge, which is a structure that looks good, but there's problems in how it's going to be implemented, is 30 days to enter conditional discharge, and also the fact that filing a motion to suppress evidence does not toll that 30 days. It looks like this language was pulled from the DUI diversion statute. I want to point out that there's a difference between DUI and PCS. For PCS, possession of a controlled substance, it's all about the search. It's all about searches. And what a motion to suppress evidence does, it's filed by defense counsel when a person's constitutional rights have been violated. And it brings to light what the bad police conduct is and deters future bad police conduct. So we want to, if we're going to mitigate some of the harm that we're going to see from this bill, from all the searches, one way is to encourage and allow these motions to suppress evidence and have that be included to toll the time window. Also, it looks like this language was pulled from the DUI diversion statute. One thing that wasn't taken from the DUI diversion statute is allowing someone to enter DUI diversion, or in this case, conditional discharge, 14 days after they receive the lab results. And it seems like there's an effort to kind of sidestep a fiscal for OSP, for the crime lab. And I'll say that if you're going to recriminalize drugs, so the cost of prosecution, and that's a necessary cost. Thank you.
Thank you. Maylee, if there is a district attorney's office that is uniformly objecting to conditional discharge, please
come
bring
to you
that to my
again.
attention.
Thank you.
Thank you. Next, we have Juanita Smallwood and Aaron and Brenda Martinek.
Good evening.
Good evening.
My name is Juanita Swartwood, and I live in the Lentz neighborhood in southeast Portland. I urge you to approve HB 4002 for my family, for my neighborhood, and for the state we all love. I am a grandmother of a beautiful young woman who is working hard as we speak to overcome her addiction to drugs. Measure 110 didn't cause her addiction, but decriminalizing hard drugs, normalizing their use, and acceptance didn't help. Oregon should be known for many good things instead of we've been known as a refuge and a destination for deadly drugs. HB 4002 will roll back the heart of Measure 110 and recriminalize hard drugs with serious penalties. That is a positive step forward. I agree that addiction is a disease and not a crime, but sometimes to break the cycle of addiction, the consequences and incentives of criminal justice are necessary and needed. HB 4002 will help in this area. We need to end the naive and tragic policies that assumes an addict will make a rational, voluntary choice. Treatment should be a mandatory alternative to jail. As a resident of Lentz, our neighborhood has been extremely hit hard by the combination of runaway homeless camps, the presence of dangerous drugs being used, being sold, stolen, and crimes that result from homeless camps and drugs. HB 4002 will give the city officials and law enforcement stronger tools to stop the use of drugs in public and to arrest and prosecute drug dealers who prey on the vulnerable, like my granddaughter. I hope our mayor, police chief, and district attorney will use this new power to make our city safe again. I hope our county commissioners will do the same with the new money for treatment. Finally, I commend you for listening today. You've listened to a lot of different viewpoints and taking in a lot, and I really appreciate it. Thank you for listening to me today, and I think this is a good start.
Thank you for being here.
Good evening, Co-Chair Representative Kropp and Co-Chair Senator Lieber. And my name is Brenda Martnick. I'm here to speak in support of House Bill 4002. I've been an educator for over 30 years, and I've worked as a K-8 therapeutic school principal, a special education director. I've seen struggles that students face when having substance use disorders and mental health challenges. I've supported creating and advocating for mental health and substance use services within a K-12 school system. But that's not why I'm here tonight. Tonight, I'm speaking to you as a mom of 4 beautiful adult children. Unfortunately, one of my sons, Taylor Martnick, he died at the age of 24 due to a fentanyl overdose. He became addicted after being given oxycodone for shoulder surgery while he was playing football at Portland State. We struggled to find treatment for our son. We struggled to get support while he was in jail, and we struggled to find recovery and support services. His family, his friends, and coworkers all provided the best support that you could provide. But alas, we alone were not able to keep him alive. Taylor wasn't proud of having an addiction. He was ashamed of it. He was scared when he was out on the streets. He lost friends, he lost jobs. He didn't understand why drug dealers could be allowed to sell him drugs right across the sidewalk when he was released from treatment. He also didn't understand how those same drug dealers could be out there month after month selling to him and his friends. When Taylor was using, he was in what we would call his drug brain. He didn't, thank you. He didn't want to help when he was in this mindset. When he was like this, he was manic, depressed, and he didn't have the ability within himself to be able to ask for services. He went into treatment 2 different times. There were no urgent beds available. There was no services and for co-occurring disorders. So what I want to point out in House Bill 4002 is that it makes some important life-saving changes to Measure 110. This bill establishes a jail-based medication for opioid use disorder fund. It provides treatment and transition services. My son sat in jail in 3 different county jails with no treatment services, no medication. This bill also creates a behavioral health deflection program, which is a partnership with law enforcement and behavioral health programs. Yes, there does need to be consequences. If there were no consequences for Taylor's actions of driving with a suspended license or driving under the influence or having possession of drugs on him, he wouldn't have been able to go. He was in his drug brain. He wouldn't have made a decision to look at a card and call a treatment center. We have to get our children through that door in order to make a difference in the lives of our children. Please pass this bill and save lives.
Thank you so much for being here. Erin?
Hello, my name's Erin Martinek, for the record, and I am speaking in support of House Bill 4002. My mom, you just heard, Brenda Martinek. My brother, Taylor Martinek, died. He was murdered. He believed he was purchasing an oxy pill when in fact it was laced with fentanyl. We have got to take back this state from out-of-state activists who lured our voters into a dangerous experiment that left us with more dead, and it's mostly the vulnerable who were not able to vote. The homeless, the people who are suffering from addiction, and the vulnerable. This House bill is critical to addressing addiction issues and limiting access to lethal drugs. Some of you, many of you, have heard from my family. We have not passed Taylor's Law, but we are not going to stop. While this is not Taylor's Law, we have been pushing for it for 5 years. And as some of you have heard in our previous testimony, there are dealers who sit outside of treatment centers and wait for people to come outside to sell to them. In House Bill 4002, one of the things it addresses is harsher penalties for those dealers, those people who are trying to hurt our most vulnerable. We need to recriminalize the possession of drugs because people are walking around with lethal items in their pockets, similar to guns, but what's different about them is you have no idea that it's lethal until you're dead. We need harsher penalties for dealers. We need treatment services for people who are suffering from addiction. Our babies are dying, and we need to stop standing by as we let dealers murder our citizens. Thank you.
Thank you for being here. Next, we have Danita Harris, Gloria Ochoa, and Mercedes, and I apologize, Mercedes, I'm blanking on how to pronounce your last name. And after this panel, we'll have Matt Scales, Matt English, and Dan Primus. Welcome.
Hello. Co-chairs Croft, Lieber, and members of the committee. For the record, my name is Danita Harris. I am a constituent of Representative Mannix and the Deputy Director of Movement Building at Imagine Black, where we envision a world where people of African descent enjoy the rights, resources, and recognition to be a thriving, resilient, and connected community. HB 4002, public defense provisions, and all of the amendments therein stand in stark opposition to our vision. Over the course of the creation of HB 4002, your committee has been provided with a plethora of data brought forth by subject matter experts, unbiased with the passage or failure of this bill. That data overwhelmingly shows that the carceral approach is a relic of failed policies from the past. You have been informed of the impacts of criminalization and are aware of the desperate impacts of such policies on the Black community. Despite knowing how woefully harmful this will be on my community, you continue to move further and further towards incarceration over treatment, sacrificing Black people, the very community that you've kept out of your closed-door meetings, to maintain political power. That is what a broken democracy looks like. It lacks innovation, it's refusing to account for data, it prioritizes oppressive institutions and business-owning class over your constituents who voted for treatment, who continue to call for treatment. This is not fundamentally different than the way that we have done things in the past, despite the way that you started off this meeting. Sacrificing our communities is actually very status quo. I have deep faith in our constituencies and believe when we voted for treatment over jails, we meant treatment over jails. It is with the greatest disappointment I recognize I have more faith in our constituencies than you do. Black people deserve a lot better.
Thank you.
Co-chairs Lieber and Croft and members of the committee, thank you for the opportunity to provide testimony in opposition to House Bill 4002. My name is Gloria Ochoa Sandoval, and I'm the policy director at Unite Oregon. I thought of being silent for 2 minutes to represent the silence I received to the last email I sent last Wednesday regarding our communications, but I've decided my words need to be heard publicly. As a reminder, Unite Oregon is a statewide nonprofit organization in both urban and rural Oregon that is led by and represents Black, Indigenous people of color, immigrants and refugees, and folks experiencing poverty, the same group of people that are disproportionately targeted by criminalization. I hear you say we need to do something to get people off the streets, decrease drug use, and save lives. I agree. Where we disagree is that means criminalization. House Bill 4002 is not a treatment-first approach. It's a treatment if you are lucky approach. Luck in this bill is defined as a county that has opted into deflection and might have included providers while planning implementation. Luck is an officer that will offer deflection and a person in possession that understands in English that their options Latinx people. That is, even though it avoided incorporating the very real disproportionate impact of the pandemic and fentanyl in low-income communities in the recent years. As a Latina, I'm tired of governments meeting my plea for help regarding racial disparities with a proposal for data collection to prove my experience true. I'm also tired of receiving data that validates my experience and does nothing about it. If you care, if you don't want to sacrifice Black lives for your quick need to do something, I would encourage you to put a threshold to these disparities and have counties who show this disproportionate impact to no longer be allowed to charge misdemeanors. Go ahead.
Thank you.
Hello, co-chairs and members of the committee. My name is Mercedes Elizalde. It is wild to me right now that I'm actually providing testimony in opposition of a bill that includes eliminating prior authorization, because that is just so important, but that also shows you how much the criminalization eats up the good in this bill. No matter how hard we try to define other people's rock bottom for them, we can't. We can build all the sticks we want, and we can't beat people into health. The racial disparities are going to happen. I've said it a number of times. Other people have said it a number of times. You have another report that says it yet one more time. Our local governments and our police and our providers need to work together. Honestly, all of the money that you want to put into this, if you just put into coordinating collaboration tables, it would produce far more than this labyrinth of criminalization with supposed off-ramps. I have this really great book here. A few legal rules meaningfully constrain the police in the war on drugs. This may sound like an overstatement, but upon examination, it proves accurate. The absence of significant constraints on exercising the discretion of police is a key feature of the war on drugs. This bill introduces tons of discretion in multiple places, increasing inconsistency in our ability to work together. Behavioral health resource networks are serving tens of thousands of people, and yes, police have not been able to figure out how to partner with those and have referred a dozen, you all have said the number, almost none. But the work is happening, the services are on the ground. You talk about off-ramps, but the only reason you need them is because we're creating on-ramps. We can't do this one drug at a time. We can't do this one community at a time. We need to be working together. Please focus on local collaboration, because this can be much simpler to fix. We don't need to make it more difficult. We need to make it easier to get care.
Thank you for being here. Next, we have Matt Scales, Matt English, and Dan Primus. And after that, we'll have Jessica Maravilla, Carl McPherson, and Jennifer Nash. Welcome.
Good evening, co-chairs Lieber, Kropp, and members of the committee.
For the record, my name is Matt Scales. I'm the Chief of Police for the City of McMinnville, and I have the privilege of serving as President of the Oregon Association of Chiefs of Police. I'm here today on behalf of the Oregon Association of Chiefs of Police to offer forward to House Bill 4002 is a strong proposal, and we fully support it. Our communities are crying out for help, and this -24 amendment demonstrates that you are listening. Oregon's drug addiction and fentanyl overdose crisis is destroying lives, devastating families, and eroding the safety and livability of our communities. There isn't a community anywhere in the state that isn't significantly impacted by the crisis, and Oregonians are angry about what they see. They're looking for all of us to work together to aggressively address the crisis, and we believe this bipartisan proposal is substantive and meaningful. According to the Centers for Disease Control, 1,650 Oregonians tragically lost their lives due to drug overdoses between September 2022 and September 2023. These are our family members, our friends, our community members. Our law enforcement officers in our state are motivated by a desire to seek positive outcomes for those who struggle with severe addiction. They're the ones on who are primary touch points in our community with those who struggle with severe addiction, and they need the necessary tools to effectuate the most positive outcomes possible for those who are struggling to keep our communities safe. Again, we strongly believe that 4002-24 amendment accomplishes these important objectives. Thank you for the opportunity for letting me testify today. Thank you.
Co-chairs Lieber and Krupp, members of the committee, for the record, my name is Dan Primus. I'm the district attorney in Umatilla County and the current president of the Oregon District Attorneys Association. And I wanted to thank you for the opportunity to address the committee tonight. And thank you for being willing to tackle the drug crisis facing our state. I know these conversations have not been easy, and I have a deep appreciation for the hard work you and all the stakeholders at the table do every day on behalf of Oregonians. I'm here tonight on behalf of the Oregon District Attorneys Association offering our support for the -24 amendment. We believe the amendments represent a meaningful policy package that will provide our communities, behavioral health, and law enforcement partners the tools needed to begin to address our severe addiction crisis and drug-related overdose deaths. I think we all know this will not be an overnight solution and will require hard work and commitment from all of us. The first step towards implementation for us has been the commitment around standing up evidence-based law enforcement-assisted diversion-like programs within our own communities. Funding for these local programs is critical. District attorneys and our law enforcement partners have committed to first divert individuals facing the PCSU charge away from the criminal justice system before deeper intervention by the criminal justice system is necessary. These programs bring to the table what ballot measure 110 and e-violations did not. The ability for local communities to stand up deflection and diversion programs that address the needs of their community with support and commitment to success from local leaders in behavioral health, peer support organizations, and law enforcement partners. I also want to briefly mention what this new drug enforcement unclassified misdemeanor means to us and why we believe it is a meaningful crime category that addresses and calls to prioritize treatments and diversion opportunities while providing meaningful incentives to successfully complete the off-ramps afforded. It is important to note that the -24 amendment makes the U misdemeanor a drug-designated misdemeanor. This important distinction provides state-funded supervision by our community correction partners. And finally, the amendment makes it clear that Oregon is not open for business to our drug dealers. The new enhancement in Section 25 make clear that our parks, treatment facilities, and shelters are safe places for families and vulnerable citizens seeking housing and treatment. The Section 24 includes a very narrow fix to directly address the case of Hubble and will shift delivery of controlled substance back to what it has been for decades prior to Hubble by expressly adding possession with intent to transfer into the definition of crime of delivery of controlled substance. There's no expansion of delivery of controlled substance under this bill, but restores the tools that will help us prosecute drug dealers with profiting off of our communities. And in closing, Dash 24 amendment provides clear, meaningful, and simple solutions to our drug crisis. We are deeply appreciative of the leadership of Speaker Rayfield, co-chairs Lieber and Krupp, and Republican leaders Helfrich and Knoop for remaining at the table with us to finalize real solutions to have the support of community partners that will make effectuating the change needed to actually work on the ground. And we urge your support in House Bill 4002. Thank you.
Thank you.
Chairs Lieber and Krupp and members of the committee, for the record, my name is Matt English, and I'm the Hood River County Sheriff and a member of the Executive Board of the Oregon State Sheriff's Association. Today, I'm here on behalf of the Oregon State Sheriff's Association testifying in support of House Bill 4002 with the Dash 24 amendments. I want to recognize and thank the members of this committee for engaging OSSA at the table as we navigated the proposed language in the Dash 24 amendments. The result shows a true partnership across both parties to address drug addiction epidemic in Oregon. In the wake of ballot measure 110 passing, the state of Oregon has seen a significant increase in overdose deaths in our community, increasing crime related to drug addiction, and a continued public narrative asking for change. OSSA took a strong position on what ballot measure 110 form should look like, with the ultimate goal of being able to divert individuals into treatment and not to jail while still holding them accountable. We have also stated several times that meaningful treatment cannot occur if there are no consequences to the use of illicit drugs. Proposed House Bill 4002 with 20-24 amendments allows for partnerships in our communities to make meaningful changes to the addiction cycle. It provides much needed resources our communities and partners need to implement diversion programs to affect that change. Most importantly, it provides the accountability of community supervision that will assist in navigating that change. Evidence shows us that drug addiction must be treated differently. The diversion programs already committed to by several county sheriffs and district attorneys follow evidence-based practices that address drug addiction in a unique way. The opioid use disorder medication grant program will provide funds necessary to county jails to stand up evidence-based medication-assisted treatment or MAT programs within their facilities. These programs are just another part of the treatment plan to address addiction in our community. The proposed bill will do excellent work in our communities. It will provide public safety our constituents expect, and will make a significant difference in the addiction crisis in our state. Thank you again for the opportunity to testify today.
Thank you for being here. We have Jessica, Carl, and Jennifer, and then after that, we will have Phil Lemon and Mike Schmidt. Chair Nash, thank you for being here. I think, Carl, are you with us remotely?
Yes, Chair. Thank you.
Great, welcome.
Co-Chair Croft, Co-Chair Lieber, and members of the committee. My name is Jessica Maravilla. I go by pronouns she, her, ea, and I'm the Policy Director for the ACLU of Oregon. The ACLU of Oregon and our partners have gotten, from many Oregonians, a lot of feedback. And this is what they told us. Oregonians want real solutions to drug addiction and homelessness. They want elected leaders to develop and pass real solutions, not false promises. It breaks my heart to say that House Bill 4002-24 is full of false promises. This bill will likely send thousands of people to jail for low-level victimless crimes of possessing a very small amount of a banned substance for personal use. I'd like to echo that the only reason we need off-ramps is because the bill is building on-ramps, which you heard today. I've heard you say people will have off-ramps away from jail and criminal records. This bill doesn't require counties to build deflection programs, nor does it require police and prosecutors to use deflection programs. You've said additional off-ramps are provided through conditional discharge, probation, and early release. However, it doesn't address the serious criminal system obstacles, including not having enough public defenders and insufficient treatment spaces. This means that the bill will create a vicious cycle of people in and out of jail without connection to treatment. It's letting police and prosecutors decide who gets treatment and who gets jail. This means that people with money, connections, or racial privilege will be more likely to get into limited treatment spaces. Black, brown, low income, and disabled people will continue to be jailed at the highest rates. It encourages police to stop or arrest people if they suspect them of having a banned drug. This means that police are being encouraged to do stop and frisk type practices, which will likely result in disproportionate police misconduct and violence against Black, brown, low income, and disabled people. Not only is this bill filled with false promises, not only will it disproportionately impact Black and brown in the most marginalized communities, but throughout this process, they have been excluded and their voices have been silenced. I urge you for a no vote on recriminalization, which includes all of the proposed amendments to House Bill 4002 and the -24.
Thank you.
Thank you.
Good evening, Co-Chair Lieber, Co-Chair Croft, members of the committee. My name is Jennifer Nash, and I am the chair of the Oregon Public Defense Commission. I'm here to share the impact that House Bill 4002, the -24 amendments, will have on the public defense workforce. First, the public health issues of addiction is one of grave concern for the commission. The interplay between the criminal justice system, homelessness, addiction, and mental health is something that we and our providers see daily. We appreciate the work the legislature is doing to address these multifaceted issues, and we support the investments in behavioral health and housing that can prevent individuals from ever needing public defense services. Through legislative investment, the commission and its providers have stabilized the number of persons who are unrepresented and have drastically reduced the number of persons in custody without lawyers since July of 2023. However, we are currently unable to secure counsel for approximately 2,800 Oregonians who have been charged with a crime who are eligible for public defenders. OPDC would need to have a contract for an additional nearly 39 full-time public defender caseloads in order to provide representation for the additional cases we believe will result under this bill. Even if fully funded for those cases, we do not believe that we can find qualified lawyers to take these cases. The end result of House Bill 4002 will be that Oregonians charged with crimes will not have qualified lawyers available for their cases. Our request is that you put, if you're going to pass this bill, that you put all of your efforts into trying to keep people out of the criminal justice system, including not having it be discretionary for deflection. Barring that, we've submitted public written comment with options that could help us build a workforce needed to provide attorneys for persons who are charged under this bill. Thank you.
Thank you. Carl?
Yes, good evening, Co-Chairs Lieber and Kropp, members of the committee. My name is Carl McPherson, the Executive Director of Metropolitan Public Defender, the largest provider of public defense services in the state of Oregon. Thank you for allowing me to testify this evening. I acknowledge the tragedies that have occurred in our state with overdose deaths and increased use of drugs. I do not deny at all that is a situation that needs to be addressed. However, on behalf of Metropolitan Public Defender, we are in opposition to House Bill 4002 and its amendments for many of the reasons that the opposition members have already stated this evening, including Chair Nash and her comments prior to mine. As we all know, substance addiction is a public health issue, not a criminal issue. And quite frankly, the criminal legal system is not functioning well currently. It is not the appropriate place to bring people who are suffering from addiction. It's not equipped to help those individuals. It too, frankly, in my 26 years, does more harm than good for the individuals that are dealing with addiction. We'd much prefer the legislature and the state focus their efforts on community-based services, including treatment, housing, and education, which would go to the underlying issues for individuals to use in the first place and would keep people out of the criminal legal system. Secondly, with the off-ramps that's been stated that's within the bill, I am very skeptical that those will actually be effective. I'm skeptical because it requires counties, law enforcement, district attorneys to actually put forth deflection programs. But more importantly, I'm skeptical because Oregon routinely ranks toward the bottom or the very bottom in this country for the need for services and the services that are available. And therefore, there's no one where to deflect anyone to. So I would really hope the legislature focuses, and I know many of you, and I know you, these are your ideals and your goals, but I hope that you focus on treatment, housing, education. Thank you.
Thank you.
Thank you all for being here.
Thank you.
Phil and Mike. And then after that, we'll have Dr. Carrie Hecox, Hank Kaster, Helen Rice, and Renee Pfeiffer, and Nick Hunter. Welcome.
Thank you, Chairs Kropp and Lieber, members of the committee. My name is Mike Schmidt, and I'm the Multnomah County District Attorney. I'm here to testify today in support of House Bill 4002. We need to take immediate action to put a stop to the open public use of hard drugs. To that end, I urge the committee to vote yes on this policy package. HB 4002 recriminalizes possession of a controlled substance, but it does so in a way that features multiple innovations that put treatment above punishment whenever possible. Conditional discharge, transitional leave, and automated expungement are highly technical terms, but each one speaks to the same philosophy, that the use of jail should always be a last resort, that everyone deserves multiple opportunities for treatment, and that the consequences of a conviction should be as brief as possible. I'm also heartened to see the inclusion of provisions that will make it easier for my office to target the drug dealers that are driving addiction on the streets of Portland and throughout Oregon. These are tools I will put to immediate use. What we've seen over the last few years as fentanyl has hit the West Coast is unacceptable, and we need to take action to help those struggling with addiction. In Portland, we see open use of hard drugs on our streets, in front of our businesses, our parks, and our schools. We absolutely cannot continue to tolerate this. We can approach addiction as the health issue it is, while also holding people accountable for how they impact our community. I served as the director of the Criminal Justice Commission in 2017 when Oregon made the decision to defelonize the possession of controlled substances. We made that decision partially in response to data that suggested the presence of significant disparities of enforcement existed in drug possession cases. We've made significant investments since then in improved policing policies and better data transparency. But as we move forward with this legislation, we must stand ready to swiftly reevaluate and adapt if evidence of these disparities reemerges in the future. And to that end, I would have liked to have seen a sunset clause. Lastly, let me affirm my commitment to fully and broadly embrace the deflection resources you will be making available with this bill. The 24-hour drop-off center will be a game changer for Multnomah County in connecting people with treatment. I'm incredibly supportive of the provisions of this legislation that will lay the foundation for prosecutors across Oregon to say that treatment should always come first. This isn't easy, addiction is complicated, and confounds any one solution. For too long, our behavioral health and criminal justice systems have worked in isolation or even opposition to one another. The deflection programming and new investments contained are the bridge.
District Attorney Smith, thank you for being here. I want to say thank you for your office's help as we've primarily trying to figure out what a deflection programs could look like, what diversion could look like, and I would say most importantly, what an automated expungement process would look like. So I appreciate that commitment to that work.
Thank you, Chair Kropp.
Welcome. Phil, welcome.
Good evening, Co-Chair Kropp, Co-Chair Lieber, members of the committee. My name is Phil Lemon. I'm the Deputy State Court Administrator from the Oregon Judicial Department. OJD remains neutral on the substantive provisions of the bill, but we do want to thank you for listening to the court's concerns and how you've approached this and the amendments that you've made, including the -24s. In particular, we'd like to thank you for postponing some of as they develop these deflection programs. As you have seen in the bill, those deflection programs can either be pre-arrest or citation or following an arrest or citation. Different communities throughout the state present those documents to the courts at different stages, and that has an effect on the set-aside or the sealing of records that is also in the bill. So we would very much like to be at the table as those get developed. We are wanting to avoid instances where a process designed without the understanding that if it's not done carefully, people can be called to court unnecessarily and even issued an arrest warrant if they fail to show. Finally, the sealing of records is a complex process for all the partners, whether it's the court or law enforcement or district attorneys, and we look forward to working with our state and local partners to develop a process that works for everybody. We'll be submitting additional written testimony, but thank you. I'd be glad to answer questions.
Thank you. We have Dr. Carrie Hecox, and we have Hank and Helen and Renee, and Nick Hunter. It might be one chair short, but we're good.
If it's okay, we'll have one sit back.
That'd be great. Thanks. Thank you for being here.
Carrie,
Doctor, go ahead.
okay, thank you. Am I go? Okay. Hi, thank you, members of the committee. My name is Carrie Hecox, and I'm an addiction medicine and family medicine physician in Medford. My practice is called the Oasis Center, and we only see families who are affected by substance use disorders. So that's my practice all day long. We have roughly 1,000 patients. 30% of them are children who have a parent with a substance use disorder. Over the past 3 years since the influx of fentanyl, we've lost 12 parents to fentanyl-related causes, leaving behind greater than 30 children who lost at least one parent, and in one really tragic case, lost both parents. I am testifying today to support the proposed House Bill 4002, particularly the jail-based medications for opiate use disorder. I want to be really clear that I don't want to go back to the war on drugs or an inequitable system. My job and what I want to do is to help people move into their fullest lives. And I agree with Senator Lieber's earlier statement about partnerships between law enforcement and treatment are possible, and they are what we need. I've personally witnessed large changes in the approach of law enforcement, and I've been part of some very positive changes. And I'm going to give you one example. Our agency works closely with the Medford Livability Team, a branch of the Medford Police Department. About 2 months ago, the Livability Team contacted me. The officer was taking one of my patients to jail. However, he knew she was established with me, and if I wrote a prescription for buprenorphine prior to her being incarcerated, she'd be able to receive the medication. The officer came to my office with the patient in the back of the patrol car, and I hand wrote a prescription for buprenorphine to take to the jail. The patient was able to start the medication, and she was released to a residential substance use disorder treatment where she is still in treatment. Had the officer not contacted me, the patient would not have been able to start on buprenorphine. And this patient had previously been incarcerated without medication-assisted treatment and went right back to substance use without that intervention. So I strongly support the passage of House Bill 4002, particularly the treatment in jails. Thank you.
Great. Thank you for joining us. Go ahead, please.
Co-Chair Cruff, Co-Chair Lieber, thank you for letting us be here tonight, members of the committee. My name is Nick Hunter. I'm the Marion County Sheriff. I'll let the other folks introduce themselves, but you've heard tonight about LEAD programs. I'm one of the only sheriff's office, one of the only agencies in the state of Oregon that actually has a LEAD program. And so I thought it fitting that let's have some of the folks that actually work in that LEAD program be able to share for you. So I will come back around and share a few comments on the end, but I think the real reason we're here is to hear from Hank Krapser, Helen Rice, and Renee Peffer.
Great. Thank you, Sheriff.
Good evening. For the record, my name is Hank Krapser, and I'm here to speak in support of House Bill 4002-24. I'm also, I've lived in this community my whole life. I'm also a person in long-term recovery from drug addiction. January of this year, I celebrated 11 years clean and sober. So prior to that, the previous 30 years were spent in active drug addiction and in incarceration. Jails and prisons, and I've spent about 16 years of my life incarcerated. So today, I'm a licensed counselor. I work for the Sheriff's Office for a program called Law Enforcement Assisted Diversion, or LEAD. And so today I get to speak to you from someone that has experience on both sides of this. And as a concerned father, you know, I drive down Lancaster every morning to take my kid to school, and I see people in bus stops smoking fentanyl, and I see kids waiting to the side because they can't use the bus stops because people are in there smoking fentanyl, because it's legal to possess fentanyl and to use it in public. And so and I hear people talking about giving folks a phone number to call for treatment instead of taking them to jail for, you know, possession of these drugs. And as someone that has personally experienced the hell of withdrawing from opiates on a jail floor next to a toilet more times than I could count, that's not a choice that a lot of us, or most of us, are going to make on our own. And so the accountability is what's missing out there, that nudge from the judge, the consequences and incentives of the criminal justice system are necessary to get these folks in a situation where they can get the help that they need. And what a time for those drugs to be illegal too. or to make them legal too. The meth is causing a mental health crisis, and the fentanyl is wiping out a generation. I'm here today asking for accountability and compassionate accountability because people are dying out there.
Thank you. Congratulations on the 11 years.
Thank you.
My name is Helen Rice. I too am about to celebrate 5 years clean in August. I have been through the system myself here in Marion County. I had about 15 years in and out of Marion County Jail. This weekend, my son, who spent 2.5 years in foster care and was returned to me, celebrated his 10th birthday. And at that birthday party was my grandpa, my dad, my aunt, my sister, her husband, my little sister, my niece, and all of those people had not been in the same room for 10 years because of my drug addiction and the choices that I made. I have 2 kids that have been adopted by the state. And had it not been for the accountability piece when I did get clean almost 5 years ago and the fear of going back to prison and never seeing my son again, I wouldn't be sitting here today working and partnering with law enforcement. We were talking, Hank mentioned a 24-hour phone number. I currently hold the 24-hour on-call phone, and a police officer can call me at any time, day or night, and I'm gonna come out and meet them and talk to the person. And not only do I get to talk to the person, I get to tell them, like, look, dude, I've been where you're at. I've got 14 felonies. I've been a drug addict. I've had 2 kids in the system, and now I'm parenting one. Now I work for law enforcement. Now I have my own apartment and a car and all that jazz, and it didn't happen overnight. But if we don't hold these people accountable, who will? Because if we don't care, why should they? I can't take my son to the mall because he's 4 feet tall and there's a woman smoking meth right outside of the doors and nobody's stopping her. I can't take him to the park here in town because people are hunched over and dying from fentanyl use. I can't be with a loved one because they have chosen, not even chosen. When you get strung out on fentanyl, it is not a choice anymore. We need the accountability piece if we want to save our community, period.
Thank you. Thank you for your work.
Hi, my name is Renee Pfeffer, and I work with the Marion County LEAD program, and I'm also an addict. I'm also an addict who would not be sitting here in front of you today if I did not receive a nudge from the judge. I went to treatment this last time in 2004 with a 6-year joint suspended over my head. I had a choice. I could go do prison or I could go do treatment. And it actually started with a 3-year joint suspended, but I just had to keep trying those waters. And when it hit 6 years, I actually spent enough time in jail for my head to clear out and for me to make a good decision. Today is actually my 20 years clean. Today is February 26th. So I celebrated a milestone today, and I'm very grateful that I was given the opportunity to go get treatment instead of going to prison. And enough about me. I want to tell you guys a little success story with the people that I work with, because my job is not my recovery. My recovery is one thing, but it enables me to do my job. It enables me to go out and talk to people and meet them where they're at and understand where they're coming from without any kind of judgment, without anything, and just hear them and listen to their needs and try to meet them where they're at, with whatever their barriers are. So I was working with a person, and when she was given to me on my caseload, she was in an outpatient treatment facility and she was using. So she would do her methadone and she would go get high. And she would, this cycle continued. She picked up a couple sanctions from her PO, and that really didn't do the trick. And then she really went out on a big run, and she ended up picking up a lot of big cases, and she was looking at 8 years, and that caught her attention. All right. And so she was able to get into a treatment. She got over a year clean. She was doing really well. She got her kids back in her life. All right. And then once she figured out she wasn't going to go to prison, she went ahead and relapsed. All right. But I did not drop her. I did not forget about her. Today, she does have 6 months clean, and she did not fall off the wagon, but she would not have had that initial seed planted without the consequences. And if we had gotten her the consequences sooner, she wouldn't have had to face all those bigger charges. Thank you.
Thank you for being here, Renee. Thank you, especially on this anniversary. Congratulations on that.
Co-Chair Crow, Co-Chair Lieber, members of the committee, thank you for allowing us to come here and share these stories. These are stories that I simply cannot share with you. I don't have the past experience, and I cannot use the language, and it just doesn't come with that empathetic sell that they can sell to you. What I can tell you is that of all the programs that I've had, and especially as for becoming sheriff, this is the one I'm the most proud of. I'm the most proud of this, and people often ask me, how do you measure? What's the metric that you use to measure? My metric is very simple, one case at a time. It's one success story that I get to hear at a time coming from my 3 navigators. Why is this so important? This is so important, and these programs are so important because they can do in 5 minutes what the rest of law enforcement cannot do in 5 years. The behavioral change curve, which you want to get to influence and persuasion, and really you want to get to someone wanting to make change for themselves. But that starts with rapport. Behavioral change starts with rapport. They're able to develop rapport in areas that we never will be able to. And what you hear from them tonight, and you just don't have long enough to, is to hear the passion that they have to make the difference in the communities. So I'm asking for that support of those lead programs, funding those lead programs. We have the ability to expand our lead program, and we could be helping more and more. I've heard about treatment. We have set up those programs. We've worked through the DA. Our program for 4 years has been sending data back through the CJC, so I can show recidivism rates that have gone down. I can show housing rates that have gone up. I can show gainful employment that has gone up. I can show the addiction and drug addiction that has gone down. I can show those rates through the success of this program and these individuals. We simply need more money to fund these programs, to expand these programs, and then we are more than happy to take this program and share it with the rest of the state, where I've had in the last couple weeks a lot of interest in simply how does your program run? What do we need to get it started, and how can we adapt it? Because every different county is going to be different. Every municipality is different. For me, I have 10 different municipalities that actually work, that we share this information with, that call that phone right there. That is the idea. And I know I'm out of time, and so I'll finish with this. I've heard it kind of several times tonight, but I think something needs to stick. This program and what law enforcement and Chief Scales, Sheriff English said it as well. We're here for treatment. Treatment is the goal of what these programs are. And that's why we have 10 agencies that can call a phone anytime they have somebody that they believe would be a good member or a good candidate for the lead program, and they will come out 24 hours a day. Without the accountability, I cannot get that person to stand around long enough to make that phone call to get my navigators out where my navigators can do good in the community. So I need the accountability so that these folks can do what they do best, which is connect with folks, get them into treatment, support them through treatment, and then build better livability in all of our communities. Thank you very much.
Thank you all for being here. Next, we have Melly Rhodes, Haven Wheelock, and EOJ Johnson. And after that, we'll have Lisa Schroeder, Jessica Burke, and Christine Burmeister.
Okay, good evening, Chairs Lieber and Croft. My name is Melly Rose. I am the Director of Operations for Iron Tribe Network, a peer-run nonprofit dedicated to providing family recovery housing and peer support. I stand before you today as someone in long-term recovery of over 13 years. However, my journey also includes experiences with the criminal justice system. I want to emphasize the harsh realities of county jail. It's a place where individuals are crammed into confined spaces with minimal access to fresh air and are provided with diets hardly fit for humans. Surprisingly, I found the conditions in prison to be comparatively better, which speaks volumes about our county jail systems. I say this only to highlight how traumatic county jail is. Many people who use drugs are only doing so to deal with their personal traumas. And adding to their traumatic history by doing a sentence to up to as many as 180 days for a drug possession is a disservice to what we're trying to accomplish. I have personally filed for an expungement of a simple possession charge in Multnomah County back in November of 2022, and it is still yet to be processed. And this is due to an overwhelming backlog. This delay underscores the broader issue of our justice system. While I applaud the easier access to expungement, this backlog proves the inability to process expungement requests. Oregon's standing in terms of access to treatment is disheartening, ranking close to last in the nation. However, Oregon has shown bravery and innovation by recognizing drug possession as a healthcare issue rather than a criminal one. We've begun to shift towards a more compassionate approach. This transition has not been swift, nor will the solutions be immediate. However, it's important to remember that we did not get here overnight. We must focus on identifying service gaps and actively work towards filling them. Building new systems takes time. Arresting individuals struggling with addiction will not resolve the underlying issues of addiction and homelessness. We must remain steadfast in our commitment to providing comprehensive support and treatment options. This is not a time for regression, it's a time for expansion and improvement. Thank you for your time and consideration. Let's stay the course and continue striving for a more inclusive and supportive system for everyone who wants recovery. Thanks.
Thank you. Haven?
Members of the committee, for the record, my name is Haven Wheelock, and I've been providing care to people who use drugs here in Oregon for nearly 20 years. I'm here today to oppose House Bill 4002 and all its amendments. There is no question that the addiction crisis in our state deserves all the attention that it's currently getting. However, people who use drugs deserve real solutions that are shown to help people heal from addiction, which is not the way this policy is written. War on drug policies have shown time and time again that they don't work to get people into care, and these policies all too often disproportionately harm Black, brown, and Indigenous people more than white people. If we could arrest our way out of this crisis, we would have done it a long time ago. We've actually tried this approach in Oregon, pre-Measure 110, and it didn't work. There's some magical thinking happening here that somehow going back to the way things were before Measure 110 is going to take us back to the 2019 addiction crisis. But I want to remind you that it was bad in 2019 and it is still bad today. Punishing people for our failures to create affordable housing, effective treatment is cruel. And those are the issues we really should be focusing on. Our addiction care continuum is so fragmented and overwhelmed and overburdened. Adding any criminal legal referrals is just going to complicate our already messed up system. I personally know people who are currently struggling to find care that can't find it. And if we're forcing people who don't want to stop using drugs into treatment slots, we're going to keep people who are actively ready for care out of those spots. I'm all for finding creative solutions to our addiction crisis and would love to work myself out of a job right now. This bill isn't going to do that. We know that because criminalization didn't work before. Why would we think it's going to work now? Thank you for your time.
Thank you. Mr. Johnson?
To the chair and committee, I just want to thank you for this opportunity to be here. I am the operations manager for the Miracles Club and every entity belonging to it. I have a lot of lived experience, even incarceration, and coming into incarceration. It never helped me. It never helped resolve anything. It didn't force me to change or anything of that nature.
Mr. Johnson, I apologize.
Yes.
Can you state your name for the record, please?
Lodge Johnson. Sorry about that.
Yeah. Go ahead. Sorry.
It's pronounced like Lodge. That's okay. And being on boots on the ground, going to the trenches, I'm there. I see what people's needs consist of, and there are some language barriers, and I'm not talking about as far as foreign, different country, things of that nature. But there are individuals that try to reach them, and for whatever reason, they're not able to, and so therefore people think that they're being ignored, yada yada yada. That's not the case. Like I said, I got a lot of shared and lived experience. Jail did not help me. It wasn't until I was released to where I could really, find my way and receive the help that was bestowed unto me. Secondly, recovery to me is we're at war. We're at war. And right now, why would you lock somebody up that's already imprisoned by addiction? Why wouldn't you give them a fighting chance, allow them to be, on this side? And instead of adding to the recidivism rate. So I appreciate the time. I strongly oppose H. Bill 4002. Thank you.
Thank you. Next, we have Lisa, Jessica, and Christine. And after that, we'll have Sandy Chung, Amanda Elmer, and Emily Hawley.
Co-chairs.
Go ahead, please.
Co-chairs, thank you for the opportunity to testify on HB 4002. For the record, my name is Lisa Schroeder, and I'm the chef and owner of Mother's Bistro and Bar in downtown Portland. I'm here to support the -24 amendment being discussed today, and I strongly encourage you to take action as soon as possible. Mother's Bistro has been open for 24 years. We're part of the renaissance of our corner downtown, a community with thriving retail, innovative hotels, vibrant tourism, and great food and beverages. The last 4 years have undone all of that. Measure 110 is killing our city. We put the cart before the horse by decriminalizing drugs before we had rehabilitation centers in place. I've never seen the level of crime, vandalism, and overt drug use as I have in the last 4 years. There's an open-air fentanyl market downtown that just moves from corner to corner. We have to reverse course now. The provisions in the amendment are essential components of a better path forward. We criminalize open drug use. That's what we're talking about. We don't allow public drinking or marijuana use. Why fentanyl? We must give law enforcement tools to end the open-air drug markets that have taken over entire city blocks. I'm not saying go back to the old ways, but we must empower law enforcement to work with treatment providers to direct addicts to detox and treatment. We must provide additional investment in those centers so we can help get folks off the streets and give them a fighting chance at addressing their substance use challenges. I can't believe Multnomah County doesn't have a 24-hour sobering center, adequate detox facilities, or a Cheers-type van to get visibly intoxicated people off the streets. How could anyone think that legalizing drugs in a state that does not have adequate detox facilities in its largest city would work? And herein lies the fundamental problem. Out-of-state interests duped Oregon voters into thinking this would be a compassionate solution to the harrowing challenges of substance and use addiction. It is not the solution and has only caused mayhem and unnecessary deaths. Together, we can take back our state and our streets, but it cannot be done unless we get rid of what parts of Measures 110 aren't working and replace them with tools that will allow us to work collaboratively to stop the rampant drug use, property damage, and death. Please get this important work done.
Thank you.
Can you hear me okay?
We can. Go ahead.
Okay. Co-chairs, members of the committee, for the record, my name is Jessie Burke, and I own the Society Hotel in Portland's Old Town, and what many consider to be ground zero of the Measure 110 crisis. I'm asking you to support the -24 amendments to House Bill 4002. I've worked in Old Town for 10 years, and I've been at work every day of the pandemic. I've watched firsthand the crisis unfold outside my doors. If you are not working or living in this environment daily, you cannot comprehend the trauma that has been inflicted on our community. Not only are our most vulnerable populations dying in numbers we've never seen, but you've asked the community at large to normalize walking by dead bodies on the sidewalk, normalize being chased by people high on meth wielding machetes, normalize open-air drug use, normalize my staff and myself being threatened by dealers when we report anything. You have asked us to normalize addiction, not just in our community, but to tourists visiting from all over the world. In fact, one of our hotel guests tried buying something outside, and we later found him dead in his room. This is not normal. Our community is suffering from a collective PTSD and collective depression, and we need you to acknowledge what has gone wrong and course correct. I encourage you all to read a recent Wall Street Journal article called "Luxury Beliefs That Only the Privileged Can Afford." We as business owners are often told we lack compassion for raising the alarm, but nothing could be further from the truth. We know all of the people living outside our businesses. We are who feed, clothe, and seek care for them most of the time, and we are devastated when we learn another person has died. Yes, addiction is a health issue, but when your health issue cannot safely be intercepted by healthcare providers alone, it is no longer a health issue alone. Not everyone responds to incentives. Some people need consequences and boundaries. The social contract we've all agreed to is that we will do no harm to one another, and we will intervene when others harm themselves or others. To normalize anything else is inhumane. Please pass this bill.
Thank you. Christine?
Hello, co-chairs, member of the committee. For the record, my name is Christine Burmeister, and I am the owner of the Daily Feast and Taylor Street Kitchen, both restaurants in downtown Portland. Lots of us voted for Measure 110 because we believed that treatment is better than jail and that addiction is a disease and not a moral failing. And it was, to our understanding, to be a two-part measure, with the second part being a treatment center. It seems that that center has never materialized, but what did happen was that the streets of Portland became taken over by drug users and drug addicts and all of the associated tragedies. We have had young customers who used to pull up and buy a breakfast burrito become addicted. You know, there was an encampment on our corner for 18 months where they openly sold heroin. People would pull their cars over and buy it. And we saw him go from being just like a normal 18-year-old kid to a absolutely pockmarked, dirty, raving addict. And now he's gone. We have had girls go in and turn tricks in the tents. We have had people set up tents as drug dealing dens, with different groups showing up in very nice pickup trucks to move in furniture and then sell drugs out of them. I have been accosted several times, as has my staff, and some of those tents were abated finally because they found enough drugs to count as dealing, plus unregistered handguns. So this is not a victimless crime. We've seen this population get sadder and sicker and angrier and dirtier and more neglected and more deeply addicted to drugs. And we want these people to get help. You know, you can't force a rock bottom, but what it seems we've done is just remove the bottom altogether, and now they're just in free fall. And it is traumatizing to all of us. I am in support of -24 and the amendments HB 4002. We need to treat these individuals as human beings who deserve help and care, and that might require consequences for their actions. The so-called compassionate approach we are currently attempting shows up as neglect. Thank you.
Thank you. Sandy Chung, Amanda Elmer, and Emily Hawley. Welcome.
Good evening, Co-Chairs Croft and Lieber and committee members. I'm Sandy Chung, she, her pronouns, Executive Director of the ACLU of Oregon. Legal scholar and civil rights lawyer Michelle Alexander writes in her book, The New Jim Crow, Mass Incarceration in the Time of Colorblindness, the following. The political dynamics that gave birth to the system date back to slavery. The declaration and escalation of the war on drugs marked a moment in our past when a group of people defined by race and class was viewed and treated as the enemy. A literal war was declared on a highly vulnerable population, leading to a wave of punitiveness that permeated every aspect of our criminal justice system and redefined the scope of fundamental constitutional rights. The war mentality resulted in the militarization of local police departments and billions invested in law enforcement at the state and local levels. It also contributed to astronomical expenditures for prison building and the slashing of billions from education, public housing, and welfare programs, as well as a slew of legislation authorizing legal discrimination against millions of people accused of drug offenses, denying them access to housing, food stamps, credit, basic public benefits, and financial aid for schooling. This war did not merely increase the number of people in prisons and jails. It radically altered the life course of millions, especially Black men, who were the primary targets in the first decades of the war. Their lives and families were destroyed for drug crimes that were largely ignored on the other side of town. When Measure 110 was passed by Oregonians, our state chose to step forward in the arc of history towards justice. With House Bill 4002-24, the Oregon legislature is proposing to knowingly step backwards and restart the war on drugs in Oregon. Last week, Governor Kotek told racial justice groups that good policy is good politics. The reality is, this bill is incredibly bad politics because House Bill 4002-24 is massively bad policy. You cannot change bad policy by simply saying it isn't so. The ACLU of Oregon urges you to help build an Oregon filled with healing and thriving communities, not more jails and prisons. Please vote no on House Bill 4002-24 and all of the amendments that support recriminalization. Thank you.
Thank you.
I've also brought copies of the new Jim Crow for all of you, and I can provide it after the hearing.
Thank you.
Co-chairs Lieber and Krupp and members of the committee, my name is Amanda Elmer, and I'm the communications coordinator at the American Civil Liberties Union of Oregon. And I thank you for the opportunity to provide testimony as a representative of that organization. This issue is very personal to me. I'm the daughter of a parent in long-term recovery from substance use disorder, and before my time at the ACLU, I was a public school teacher in this state, and I'm deeply familiar with the devastation that drug incarceration has on families. Yes, our youth are suffering from this crisis too, and like all of you, I wish to address that suffering. But HB 4002-24 is not the solution to that suffering. In fact, it would increase Oregonian suffering of all ages exponentially. Walking back on the key components of Measure 110 and making low-level drug possession a crime will not only divert tax dollars away from real solutions like treatment and education, but it will also funnel people experiencing drug addiction into a criminal system that is ill-equipped to handle the needs of Oregonians. This will not help our youth. It has been made crystal clear that our public defense system is overwhelmed with current caseloads. Adding hundreds or even thousands of cases as a result of this bill will only backlog cases further, harming the many people who cannot afford an attorney and victims of crimes whose cases are stalled. This will not help our youth. A vote for this bill also means there is an obvious lack of concern for the safety and well-being of our Black and brown communities who will disproportionately be harmed through stop and frisk practices, which are steeped in racism and threats of police violence. Police statistically target Black and brown people more than white people, will continue to arrest and jail them at higher rates than white people, and in turn, Black and brown people will be less likely than white people to gain access to our already limited treatment options. This means more Black and brown families being disrupted and ultimately more overdose deaths and suffering. This will not help our youth. For these reasons, the ACLU of Oregon vehemently advocates that you vote your conscience. And for our children, no on HB 4002 and the -24 amendments. Thank you.
Thank you.
Chairs Krupp, Lieber, and members of the committee. I'm Emily Hawley, and thank you for the opportunity to testify on behalf of the ACLU of Oregon today in opposition of House Bill 4002 and its amendments. Like the -1 amendment, the -24 rests on the fiction that Oregon possesses adequate public defenders for this massive influx of cases and sufficient services for this massive influx in mandatory treatment. We do not. As of this morning, there were over 2,700 unrepresented people in Oregon. Meanwhile, Oregon treatment providers turn away hundreds of Oregonians a month. We simply do not possess enough services to meet the needs of people who want them. This means that most people arrested for possession under any of the proposed frameworks will be unable to obtain counsel and released back into the streets with no treatment but a new arrest on their record. If lawmakers feel they must move forward with criminalization, we call upon them to implement the following accountability measures to lessen the harms and the violence of criminalization, including the following. First, counties, police, and prosecutors must create and engage in mandatory deflection programs, or must have deflection programs. Deflection cannot be optional for counties or for law enforcement. Second, the criminal penalties must not take effect until every county has established a qualified deflection program that is accessible to all people in the county. Third, we must limit the offense of possession to possession of a controlled substance in open view. This provides tools to police while limiting their ability to profile or harass low-income and Black and brown community members. Finally, to set a sunset on the criminal provisions, at which time lawmakers can review the consequences, the impacts, and the costs of these policies. We ask you not to pass any bill criminalizing addiction, but at minimum, please do not criminalize without these crucial protections. Thank you.
Thank you. Next, we have Mayor Steve Calloway, Mayor Heidi Loeb, and Mayor Alex Johnson, and they'll be followed by Commissioner Bethel. Do we have the mayors?
Good evening. I'm just waiting for my camera to be restored. It says it's been disabled.
Okay, who did that? Mayor Loeb, do you want to start us off? Great.
I'm just fussing a toddler out the door so you all can hear me. Good evening, co-chairs Krupp and Lieber, members of the committee. I'm Heidi Loeb, the mayor of Tigard, and I'm here today on behalf of the Metropolitan Mayors Consortium. Thank you for your work on this really important issue. The MMC represents the mayors of 24 cities in the Portland metro area, collectively home to over 1.7 million Oregonians. I'm here to express our support for House Bill 4002 with the -24 amendment, aimed at addressing the deeply rooted addiction crisis of our local communities. You know, mayors are on the front lines of this crisis, and we're your partners to help solve this problem. Drug-related crime, overdose deaths, and related public health crisis has shaken and impacted our communities. We believe that penalties, coupled with increased access to treatment and rehabilitation services, are the most effective way to address the present crisis. This will reduce the acceptance of fentanyl use, protect vulnerable populations from exploitation, and ultimately improve public safety and health outcomes for all. This approach will not work without sufficient behavioral health and treatment resources. HB 4002 with the -24 amendment would allow us to shift to a multifaceted approach that weaves sanctions with treatment to provide the support that those in crisis need. This moves Oregon forward with a public health methodology rather than punitive or non-interventive approaches. This will lead to better outcomes and create a safer and more compassionate community for all. The MMC is your partner in addressing this addiction crisis, and we strongly urge you to support the House Bill 4002 with the -24 amendment. Thank you.
Thank you, Mayor. Mayor Callaway?
Thank you. Good evening, Co-Chair Lieber, Co-Chair Krupp, and the members of the Joint Committee. I'm Steve Callaway, Hillsborough Mayor, and the immediate past president of the League of Oregon Cities. The League supports the adoption of the -24 amendment. Simply, it's what we asked for. We worked in coalition with police chiefs, sheriffs, and district
Mayor Johnson, welcome.
Thank you very much for having me again, Co-Chair Lieber and Krupp, and members of this important committee. I am Alex Johnson II, Mayor of the City of Albany, Oregon. Thank you for cities and the well-being of our small businesses. On a personal note, having lost a loved one to these insidious drugs, more than one, by the way, thank you for sending this clear signal
three things. Prioritize individuals' ability to engage in substance abuse treatment. Provide sufficient funding for county behavioral health and safety services and facilities. And to provide tools the criminal justice system can use to fight illegal drug use and sales. AOC believes in the -24 amendment attempts to strike this balance, supporting and strengthening the behavioral health system while reestablishing law enforcement's vital role in tackling this crisis. Essential components of the -24 amendment include increasing access to medications to treat opioid addiction with withdrawal through expedited health insurance, prescribing and dispensing processes, and through the Oregon Jail-based Medication and Opioid Use Disorder Grant Program, establishing the Certified Community Behavioral Health Clinic Program, designating the unlawfulness possession of a controlled substance as a new misdemeanor. If there's one thing that you can take away from tonight's testimony, please remember the significant and substantial funding is absolutely critical to operationalizing anything that comes out of this -24 amendment. Thank you for your time.
Okay, thank you, Commissioner. Next we'll hear from Jackie Yerby, James Comstock, and Rachel Phillips. After them will be Julie Ray Joy, Emily Grace Cropper Russell, and Tim Murphy. We have Jackie, Rachel, and James.
And this is Emily Grace. I just
Great.
asked her to come up. Okay. Co-Chair Lieber, Co-Chair Kropp, members of the committee, for the record, my name is Jackie Yerby. I use she, her pronouns. I am testifying in my capacity as the Director of Community Engagement for the ACLU of Oregon. I am here to bear witness with my colleagues, our coalition partners, especially the BIPOC-led organizations and Black, Brown, and Indigenous Oregonians who will be harmed by the solutions in the -24. As I've said previously, I've worked alongside you, Senator Lieber, Representative Sanchez, Representative Nose, who's not here right now. I know you, and I know that you are in an incredibly tough position. You have taken a bad bill and have made it so much worse. Leaving discretion to counties about whether to even implement deflection and diversion programs, and to law enforcement to decide who gets access to these programs, is an invitation to perpetuate the structural racism that is deeply ingrained in our criminal legal system. Geography-based justice is no justice at all. It bears repeating that your solutions will strengthen the foundation of structural racism in the criminal legal system. I know that is hard to hear. Imagine how hard it is for the Black, Brown, and Indigenous Oregonians, families, and communities that will feel the lash of this legislation. Sadly, structural racism is the strongest foundation of this bill. The rest of it is built on sand. Where are the public defenders who will be needed to represent people arrested under this bill? When will the optional deflection and diversion programs be stood up? Will criminalization go into effect before these programs exist? The seeming lack of consideration for these questions will make the Measure 110 implementation look flawless by comparison. This solution will fail. Oregonians deserve better.
Thank you.
Sorry. Co-Chair Representative Kropp, Co-Chair Senator Lieber, and members of the committee. Thank you for the opportunity to share testimony today. My name is Emily Grace Cropper Russell. I use she, her pronouns, and I work as the Donor Engagement Officer with the ACLU of Oregon. I live in Newburgh, and I've worked in social services for the past 10 years. I urge you not to move forward with HB 4002. Before working at the ACLU, I worked at Habitat for Humanity in Yamhill County. Through this work, I saw firsthand how Oregon's addiction crisis and affordable housing crisis coincide. We know that stable housing is imperative in addressing addiction. A loss of housing can contribute to the cycle of addiction, and services are harder to access without a home. HB 4002 will exacerbate
mentally ill clients in jail who are waiting to be sent to the Oregon State Hospital for aid and assist evaluation. Defense investigators are often the bridge between the complicated lives of clients and their interactions with the legal system. Without skilled, willing, and available defense investigators, attorneys have to use their limited time doing the things that should be done by the defense investigators, something that is costly and often impractical due to attorney caseloads. More often, if an investigator is not available, cases simply languish, taking up expensive attorney and judicial time until the client is picked up by police and the entire cycle begins once again. We usually see with a lower level charge, there's less defense investigation time needed. But because so many people who are likely to be charged under this bill are transient and in unstable life situations, cases charged under HB 4002 will likely use an unusual amount of defense investigator time. We urge lawmakers to consider these increased costs in considering this measure and how it will be funded. Currently, in addition to the dire lack of public defenders available in Oregon, there's a similar lack of defense investigators. Defense investigators are spread very thin. They are generally needed on murder cases and other complex cases involving the potential for very long prison sentences. We've struggled to recruit new defense investigators to fill the growing need, but historically low pay for investigators who are currently paid a rate 27% lower than what we were paid in 1985 when adjusted for inflation, and the lack of formal state-sponsored training and mentorship programs cause a supply of new investigators to fail to keep up with the demand. We urge you to consider these issues with regard to the bill and to fund public defense accordingly based on the anticipated increased needs. Thank you for letting me talk to you today.
Thank you. Rachel.
Chair Krupp, Chair Lieber, members of the committee, my name is Rachel Phillips, and I'm a criminal defense attorney practicing in Oregon. I've been practicing since 2005. The first 14 and a half years of my practice, I was at Metropolitan Public Defender in Portland. Now I practice across the state of Oregon. So far, I've practiced in 9 counties. When I last testified in front of you on February 7th, I noted that there were 2,728 unrepresented persons across the state of Oregon. When I checked on Friday, so barely 2.5 weeks later, that number went up to 2,800 unrepresented individuals. So it jumped 72 people. And I would note 2 of those cases are murder cases. So if you increase the flow of B misdemeanors, people are going to be going without representation on murder cases and Measure 11s. And that's going to impact the defendants and their families, and again, the crime victims and their families. Delay of serious cases has an overwhelmingly horrible impact for crime victims, especially serious crimes. Flood the system with, let's see, from the racial and ethnic impact statement, 1,523 new cases added to the 2,800. That puts us to almost 4,000 new cases. Again, I ask you, where are you going to get the public defense attorneys to take these cases? There aren't any. Furthermore, as this committee has gone forward, and I understand it's complex, but you have left public defense voices, criminal defense voices, members of the Black and Brown community, Indigenous communities out of these conversations. When my 14 years at Oregon at Metropolitan Public Defender, I lost clients to overdose. I lost clients to crime. I lost clients to suicide. The individuals who work most closely with people suffering from addiction are the public defenders, not the district attorneys. We are the ones who see firsthand the devastation that happens to our clients, and we are the ones who struggle to find them places in treatment centers, not district attorneys. I oppose 4002-24, and I oppose any other amendments, and I urge you to vote no. Thank you.
Thank you. Next, we have Julie Ray Joy, Tim Murphy, Beth, I apologize, pronunciation of your last name. Beth, great. Is she here? Great, thank you. Welcome.
Hi. Hello, co-chairs and members of the committee. My name is Julie Ray Joy. I'm the founder and executive director of the nonprofit Black Joy Oregon and a small business owner in the Salem-Keizer area. I am in opposition of 4002. I am someone who was lucky enough to escape the hell that is generational addiction without arrest and and by using harm reduction methods, and who knows that relapse is a reality of recovery and should not be criminalized. Being someone lucky enough to have been privately provided with low barrier housing, which gave me the time I needed to find culturally specific care, which ultimately paved the way for my long-term success. If law enforcement and tough on crime tactics could fix this issue, I ask then, how did we get here? The conflation of issues surrounding causation, overdoses, and criminalization is alarming and will cause more deaths. You cannot put a one-size-fits-all approach to recovery. A nudge from a judge might heal one and break another. For every story of success I can show that has worked in that way, I can show you several whose situation has been drastically made worse by arrest and incarceration. The response has been to throw the Measure 110 baby out with the bathwater and propose quickly written, and in my opinion, and in the opinion of many, reckless legislation that those tasked with its implementation have told you will not work. And instead create larger issues within our criminal justice system than we are dealing with today. As a Black woman and servant to Black Oregonians, it has been heartbreaking to watch the lack of transparency in this process. It has been extremely painful to watch the Black community be used as a pawn. While my legislators support the continuation of policy that does not work for the majority of those trying to heal from addiction and trauma, we might have been at the table, but we were not heard. I believe some just wanted to be able to say that you did your best, knowing that you didn't really care about the racial impact of what you are proposing. This process has been hasty and exclusionary at best and upholds racism and ableism at its worst. I implore you to vote no on 4002.
Thank you. Beth?
Co-chairs Lieber and Croft and members of the committee. For the record, my name is Beth Chavilicek. I use they, them pronouns. And I'm here in opposition of House Bill 4002 and all of its amendments. I understand that by stating that, some of you have already chosen to stop listening to me, unwilling to hear how this proposed bill could inflict direct harm upon Oregonians. I encourage you to resist that instinct, to lend your ears not just to me, but to other folks who share my same sentiments, and to truly comprehend the gravity of the harm you may unleash by passing House Bill 4002. I urge you to sit with the discomfort that this bill embodies. Recriminalizing drug possession to any extent would have detrimental impacts on Oregonians everywhere. Rather than arresting people who are using drugs, perhaps we should focus our energy and resources on helping those who are hurting. We can do this by ensuring that rehabilitation centers and housing are accessible and available, by creating more safe injection sites, by providing public education on how to use drugs safely, by treating Oregonians like the humans they are. Reading and watching the reactions to Measure 110 has made one thing abundantly clear to me. We are forgetting that there are people who are hurting and struggling. And instead of holding out a hand to help, you are kicking them to the ground. I recognize that you have a difficult task at hand. I also recognize that there is an election coming up and the impacts that may have on your votes. Know that this will also impact your constituents and their votes in the upcoming election. House Bill 4002 is a labyrinth where individuals find themselves navigating through a complex web of choices, each leading to the dead end of criminalization. The very act of being put in a maze, akin to being caught with drugs, triggers a sequence of events that almost inevitably leads to a criminal outcome. House Bill 4002 is like a map that purportedly guides people through the labyrinth, offering what may seem like choices along the way. However, upon closer examination, these choices often converge into a singular punitive destination. The legislation may claim to provide options for rehabilitation and diversion, but in reality, it perpetuates a cycle of criminalization. I urge you to vote no on House Bill 4002 and any other bill that criminalizes drug possession. I urge you to end the war on drugs. Thank you.
Thank you.
Good evening, Representative Croft, co-chairs Croft and Senator Lieber. My name is Tim Murphy. I'm the CEO of Bridgeway Recovery Services here in Salem. We are a drug addiction and mental health, behavioral health clinic that serves about 1,000 patients a month. I've been in this field for 30 some years. All of it here in Oregon. Some of you I know quite well. I appreciate the opportunity to speak with you today. Those of you that have a history in Oregon know that this problem we're in with behavioral health crisis and addiction crisis has been because for decades we underfunded these services in this state. And it's only recently, with the passage of Measure 110, did the recent infusion of investments result in increased treatment capacity and increased access to treatment. But that's really new. So a lot of what we're struggling with today is still remnants of the fact that we had a system that was severely broken. I'm pleased to see the infusion of the Measure 110 dollars across the state building access to services. But that's really not the question tonight. The question tonight that you're struggling with is recriminalization and something that's undefined called what's the word I want? Deflection. That's right. We don't really know what that means. I provide treatment for mental health court, for family court, and drug court in Marion County, and we don't know what deflection means. Currently, that aspect of Measure 110 needs addressing, the recriminalization part, but fentanyl was here long before Measure 110. It's increased throughout the West Coast since 2013 and contributed to overdose deaths significantly. But Measure 110 did not create that. I want to support House Bill 4002. In most of it I can, but I cannot support the recriminalization. What recriminalization does, it makes it hard for Oregonians to go forward. It creates barriers to getting a job, and it's barriers to obtaining housing. It will increase homelessness and create problems that will impact the entire state. Going back to a failed approach of criminalization is instead of going forward to a time of hope and recovery. The cute phrase is nudge from a judge, but really it's a trail to jail. So if we can work on this together. Treatment wasn't invited to be part of this proposal of developing this bill. I really encourage you to not approve the bill as it is, but send it back for further work and invite treatment providers to participate in that bill. Thank you for your time.
Thank you. Thank you all. Next, we have Nicole Rooney, Metzen Rodriguez, Rachel Wallace. They'll be followed by Mariana Garcia Medina, Kennedy Parrish, and Gracia Rojas. We have Nicole, Metzen, and Rachel. Good evening.
Yeah, Nicole.
Yep. Nicole Metzen, am I saying that right? Great, thank you. And Rachel. Great, go ahead when you're ready.
Do you want to go first, Nicole? You want to start right? Okay.
Co-Chair Lieber, Croft, and members of the committee. My name is Ray Wallace, and I use they, she pronouns. I am the Policy Support Associate at the American Civil Liberties Union of Oregon and am providing testimony in opposition of House Bill 4002-24 this evening within that capacity. Our organization is dedicated to advancing and protecting the rights of each civilian that are protected within the restraints of our Constitution, including the Oregon State Constitution. I have lived in Oregon most of my life with ancestors who have been here since the beginning of the 1900s. It wasn't until I took jurisprudence as a freshman in college that I would have my first real education around issues of critical race theory, feminism, and queerism, philosophies that we had to create because no one was listening to folks of oppressed identities. I sought to learn better and do better, and it was hard, self-actualizing work. In 2020, Oregonians demanded through ballot measure 110 that our state address the crisis that we are seeing on our streets and within our homes. In 2022, Oregonians passed ballot measure 111, making access to health care a constitutional right. This committee has a duty to uphold the laws agreed upon by its constituents and not to be swayed by voices with larger pockets. Despite the 300% increase in services regarding addiction, our state is only at 50% capacity to meet the needs of our communities, with Hooper Detox turning 200 people away each month. We are also seeing Measure 110 citations being handed out to Black Oregonians at 2 times the rate of white Oregonians. No one has a right to deny someone access to health care, and our state has a constitutional right to uphold that care being not only accessible but affordable. Investing in the addiction crisis is not something to be debated. It is something that constituents have demanded year after year. Addiction is classified as a mental health disorder, and despite that, there are laws all across our country designed to further harm and shame folks dealing with a disorder that is deeply rooted in shame. Discussions around addiction in our state have a clear racial impact and will deepen our unjust relationship to Black Oregonians. The state should be prioritizing rewriting its wrongs, and recriminalization is many steps away from that necessary goal.
Thank you.
Thank you.
Co-chairs Lieber and Croft and members of the committee, thank you for the opportunity to provide testimony in opposition of House Bill 4002. My name is Metzen Rodriguez, and I'm a South Coast constituent of Coos Bay, Oregon. I am here in opposition of House Bill 4002 and all of its amendments. Over the past few years, we have seen how the prison industrial complex negatively impacted community members, especially Black, Latinx, and Indigenous people. According to a report by Tufts University, mass incarceration in the U.S. amplifies the racial disparity in incarceration rates amongst people of color. Specifically, 1 out of every 3 Black boys and 1 of every 6 Latino boys born today will be affected. Today, I am here to stand for vulnerable communities, Black, Indigenous, people of color, and people with limited English proficiency, and the hurt parents who oftentimes lose their kids to the hands of police. When it comes to addiction and substance use, what we need are accessible and cultural adaptable resources towards rehabilitation, not another police call, not another criminal record. If this bill passes, it will only add to the prison industrial complex through cycles of conditional discharge, probation, and early release. We need treatment spaces and actual long-term funded resources and not another temporary Band-Aid solution. By passing this bill, you are leveraging a system that continues to fail. You are setting up Oregonians for failure. We ask you to evolve with the times, center resources for our communities, and be there for your constituents. Everyone deserves a second chance, not more jail time. Thank you.
Thank you.
Co-chairs Lieber and Kropf, members of the committee. For the record, my name is Nicole Rooney, and I'm a social work student at the University of Portland. Last week, I sat in many meetings with your constituents and heard lots of statements from legislators about how the people of Oregon overwhelmingly support overturning Measure 110 and how House Bill 4002 and its amendments won't cause further harm. Their constituents were there to say otherwise. They shared their personal stories and experiences of encountering law enforcement for drug use and navigating criminal records. We were told that polling is in favor of recriminalization despite the vast number of people who have come to testify in opposition to this committee. If you're not listening to constituents, who are you listening to? Some of you have talked about the ample opportunities for deflection, as if that process is simple and accessible. Conditional discharge, probation, and early release aren't real solutions, nor will they be straightforward to navigate. The Oregon Supreme Court's Chief Justice stated herself that our system is not equipped to execute this legislation. Deflection is not mandatory for counties and will be voluntary for law enforcement to offer it. This will allow for further disparities across the state that are already felt in the lack of healthcare and treatment facilities. Infusing more money into the criminal justice system is taking money away from the solutions Oregonians asked for: more mental health support, treatment beds, housing, prevention programs, and crisis response. I don't disagree that we find ourselves in a crisis and that we must do something, but the way forward cannot be a mirror of the past. We must focus on things that will move us in the right direction, and Measure 110 was the first step getting people the care that they need and deserve. Please do the right thing and vote no on all proposed amendments of this bill. Thank you.
Thank you. Mariana, Kennedy, and Garcia? Am I saying that right?
Co-chairs Croft, Lever, and members of the committee. My name is Mariana Garcia Medina, and I work for ACLU of Oregon, but I'm providing my opposition testimony as personal testimony. As someone whose brother was formerly incarcerated, I can attest that the impact and ripple effects of incarceration go far beyond one person at one time. They extend to their loved ones, their community, and for so much longer post-incarceration. I continue to hear the words off-ramps on House Bill 4002, but the reality is these off-ramps do not consider the harm of recriminalization, nor the reality of addiction. It is not an off-ramp if not every county will be required to offer deflection programs and provide treatment. It is not an off-ramp when people can opt in for conditional discharge over trial, but can lose that conditional charge for relapsing, which is very common on one's way to recovery. It is not an off-ramp when district attorneys and judges will have discretion on giving someone conditional discharge or jail because they may deem it not in their best interest, but jail will be. It is not an off-ramp if you're Black and brown and will face a harsher punitive implementation. Right now, there are individuals on the waiting list ready for treatment. House Bill 4002 will punish them for not being able to get the treatment that is not available to them. They will be punished for the state's failure. This is not a treatment-first approach. It is a punitive approach. House Bill 4002-24 will revert to criminalization instead of supporting people dealing with addiction, their families, and their communities. By doing this, you will be extending a cycle of harm that we have seen on the war on drugs that especially has targeted Black and brown communities, many who today are still experiencing the harm and impacts today. It is incredibly disappointing and heartbreaking that despite research, despite statistics of racial impact, and most importantly, despite the lived experiences, we are here considering this bill that will criminalize poverty and will devastate people's lives. I urge you, I plead you to vote no on House Bill 4002. Thank you.
Thank you.
Thank you. Co-Chair Weber and Croft and members of the committee, thank you for the opportunity to provide testimony. My name is Kennedy Parrish. I am the Communications Associate for the American Civil Liberties Union of Oregon, and I provide this testimony as a representative of the ACL of Oregon today. I strongly oppose House Bill 4002-24. I come from a family with struggles in deep vulnerability to drug addiction and witnessed my father being incarcerated at 5 years old. By my own experiences and awareness of the terror and pain for Black and brown Americans from the failed war on drugs, there is a lack of morality, practicality, and care for Oregonians in this bill. House Bill 4002-24 advocates for deflection, yet few deflection programs exist, and the bill does not require more to be created. Even if programs are created, counties, police, and prosecutors would get to choose who's offered treatment versus jail. This means that people with money, connections, or racial privilege will be more likely to get into limited treatment spaces. Black, brown, low-income, and disabled people will continue to be jailed at the highest rates. Arresting Oregonians will overload our criminal justice system with thousands of new, low-level, victimless cases where people are charged, receive minimal access to treatment, undergo severe separation from family and friends, and are released with life-damaging criminal records that will make it more difficult to get housing, government assistance, job, and education. These examples are only a glance at the devastation and pain that will unfold from arresting, criminalizing, and traumatizing Oregonians who need care, not jails. By opposing House Bill 4002-24, you have an opportunity to acknowledge that addiction is a public health issue, not a criminal one. I urge you to act with your conscious courage and compassion by voting no. Thank you.
Thank you.
Chair Lieber, Chair Kropp, and members of the committee. For the record, my name is Gracia Rojas, and I am the Development Associate at the American Civil Liberties Union of Oregon. Thank you for the opportunity to share my testimony today as a representative from the ACLU, and I am saying that I strongly oppose House Bill 4002, which would recriminalize the health crisis of drug addiction and return the state of Oregon to the violent war on drugs. House Bill 4002 does not address or work to fix the systemic mishandling of the addiction crisis, and it seems to only provide a door for the criminal system to once again target our most vulnerable community members. If House Bill 4002 is passed, thousands of Oregon residents throughout the state will be immediately put at risk of being thrown in jail without access to proper legal defense and deflection programs. House Bill 4002 does not require every county to create deflection programs, and police and prosecutors are not required to use them, even if there were an abundance of these programs, which there currently is not. How can Oregonians be expected to believe that House Bill 4002 will not be a return to the war on drugs if the very language of the bill seems to indicate that there will be no effort on behalf of the legislature to ensure otherwise? By not requiring access to deflection programs across the state and not requiring police and prosecutors to use them as the first course of action, you are giving these entities the authorities to pick and choose who receives treatment and who will go to jail. As a result, people with money, connections, and racial privilege will be more likely to be entered into a deflection program. And as history and data shows, it will be Black, brown, and low-income people who will be targeted and jailed at disproportionately higher rates. As we have seen in the very data that was provided tonight, it will be Black and brown communities who will be targeted the most, as they always are. The trust between Black and brown communities and the police is just not there. And how can it be when they continue to be thrown under the bus by this system? You expect the votes of Black and brown communities during elections, but have no problem considering them collateral damage at any other time. By passing this bill, you will be setting Oregon on a path of further harm and walking back hope that there might finally be an end to the war on drugs. Thank you.
Thank you. Thank you for being here. Isabella Villarreal, Yvonne Garcia, and Lucy Pierce. Isabella, are you with us remotely?
I am. 1 second, please. Thank you.
Welcome.
Hi, my name is Isabella Villarreal. I work for Next Step Action Fund, and I'm here today to testify against House Bill 4002. Frankly, I'm really disappointed, I'm really embarrassed, and I'm really upset that we all have to sit here and beg for the bare minimum, for the solutions that we actually know work for our communities, but instead, Black and brown communities continue to be shut out of the policymaking process. We aren't listened to during testimony, and just all the amendments continue to get worse. I'm going to share a note from our executive director, Alana Wilson. She says this: as the eldest daughter of a woman who struggled with addiction almost my entire life and overdosed 3 years ago, I know firsthand the need for healing. But it's just that, healing. The testimony that's been given by family members of people who have died due to drugs, what I continue to hear is that there weren't enough services. I agree. That means that we need to invest in healing and programs that actually work. Jail never worked for my mom. And though it has worked for a number of individuals, they are the exception, not the rule. Success through jail is the exception, not the rule. Our people need healing, not prison. And, I'm gonna leave it at that. I heard a lot of people in 2020 say that they believe Black Lives Matter, but you don't if you pass something like this. Thank you.
Thank you.
Do you want to go?
Co-Chair Lieber, Co-Chair Kropp, members of the committee. My name is Yvonne Garcia. My pronouns are she and her, and I am the Deputy Director at the ACLU of Oregon. I am providing testimony this evening in opposition to House Bill 4002 and its amendments. Over 25 years ago, I started my career as a social worker, working with chronically homeless adults struggling with addiction and mental health issues. When I arrived in Portland 20 years ago, I continued this work, and I continue to see how the revolving door of criminalizing poverty and drug addiction is a cycle that is nearly impossible to get out of without support, housing, and access to various types of treatment. House Bill 4002 and its 24 amendments is a step backwards. The proposal of jail time for small amounts of possession is harmful to our communities and an already overburdened judicial system. Please do not vote on policies that will continue to perpetuate racist and biased actions like stop and frisk practices or leaving decisions to prosecutors for treatment rather than the individuals or their support systems. Funding the criminal justice system has been the way it's been done for decades. Let's not continue with the same ineffective and expensive interventions, but let's move towards what the research and experts tell us is needed: supportive housing, access to readily available treatment, non-police emergency response teams, and access to healthcare. Please vote in support of the care of our most vulnerable community members and vote no on HB 4002 and its 24 amendments. Thank you.
Thank you.
Hello, co-chairs Lieber and Croft, and members of the committee. My name is Lucy Pierce, and I'm a student at the University of Portland, graduating in May with a bachelor's in social work. I am here to strongly oppose Bill 4002 and any proposed amendments because Oregonians deserve and want better. Addiction is not a crime, it is a healthcare issue, and putting people in prison only increases harm to our communities. Punitive actions will not solve addiction, rather waste taxpayer dollars and cause insurmountable harm by putting people who use drugs through the criminal justice system. Not to mention how these tactics will disproportionately affect Black, brown, and low-income and other underserved communities. We need to invest money into housing initiatives, outreach programs, and quality healthcare services. Oregon citizens voted for Measure 110 because we believe this crisis demands action, but we cannot punish people for the shortcomings of the state. Measure 110 was never fully implemented, and we must give the measure more time before returning to ineffective, expensive, and inhumane policies that perpetuate racist and discriminatory practices. Criminalization is not a real solution to addiction, and I adamantly oppose any action that will put people who use drugs in jail. That is why I urge you to vote with compassion and do the right thing and vote no on House Bill 4002. Thank you.
Thank you for being here. Do we have Allison Myers here? Good evening.
Hi, everyone, co-chairs and members of the committee. For the record, I'm Dr. Allison Myers. I have the honor of leading the Family and Community Health Program of the Extension Service at Oregon State University, and I'm here to provide you a little bit of information regarding the -18 amendment requested by Rep. Mannix today that would support our team at OSU Extension to convene and facilitate the community planning process that's called Community Conversations About Mental Health. The Extension Service is the outreach and engagement arm of your land-grant university, and we provide information and expertise to help meet local challenges and help every Oregonian thrive. Most people know us for our nutrition and food security work. Since 2019, and with only external funding, however, OSU has been working to promote mental health and to prevent disordered substance use and tragic deaths from suicide and overdose. You may have heard of some of the programs. Coast to Forest is one, Farm and Ranch Stress Assistance another, and the Agri-Stress Helpline for Oregon. Broadly, we work as health educators and trainers and convene cross-sector partners for systems change. The community conversation about mental health is an evidence-based practice we've led so far in 6 Oregon counties: Columbia, Clatsop, Malheur, Tillamook, Umatilla, and Union. It's a structured series. It's an evidence-based practice that came out from SAMHSA nearly 2 decades ago. We adapted it for rural and remote Oregon, And essentially, it brings together public health, public safety, prevention, recovery, treatment providers, the school district, you name it, together from sharing their own experiences to building a prevention, treatment, and recovery system map, addressing gaps collectively in the system and planning for solutions. The goal ultimately of the series is to build on strengths, to address gaps, and to make informed decisions about resources. Thanks for letting me share this information. We're ready to contribute, and we're pleased with what we're seeing as a result.
Thank you so much.
Yeah.
Do we have Shelley Walling here? Is Shelley Walling here? Do we have Belinda Trevino Ochoa here? Belinda? Okay, great. I'm probably going to call somebody remotely, Gloria. I'll probably call somebody remotely, and then when she gets... do we have Aaron Meacham with us online? Aaron? Do we have William Lovelace here?
Aaron's name's up on the thing, on the
Aaron, can you hear us?
EM.
Aaron, we'll come back to you. Do we have William Lovelace here? Do we have Melora Golden with us?
I'm here.
Great. Go ahead and begin.
Okay, hello. Wasn't expecting to go right now. I am a voter. My name is Melora Golden, and I am in opposition of the recriminalization of drugs, and feel very disheartened about the idea of law enforcement and DAs being the one to determine whether people can have treatment or not. While I respect their skill set, they are not professionally trained to make determinations around something like a significant mental health situation, which is what people who are dealing with addiction are in. They're in a neurological crisis, basically due to the imbalance that addiction can cause in people's brains. For someone who's dealing with that situation, they do need a system to go through, and society also needs a system for them to go through. And ballot measure 110 acknowledged that the criminalization system was not the right system for these people. And I ask you to please respect the voters' awareness and knowledge of that. However, there does need to be a system to support people who are dealing with addiction, and also to support society in, the outcomes, the negative outcomes of that. It seems like that system is not adequately developed, and that's part of the reason there is a problem and there's lots of stress going on right now. So please do not recriminalize drugs, and please invest in creating a treatment system to support people and society in dealing with these issues. And I understand that that is a difficult task to create a whole new system, but it is a very honorable one. And it is what we need to do to move forward in addressing these issues in a real way. Thank you for your time. And I appreciate so much everyone who's put their heart into their statements tonight. Thank you.
Thank you. Welcome, Belinda.
Thank you. Good evening, co-chairs, members of the committee, and everyone here supporting and with their testimonies. For the record, my name is Belinda Trevino Ochoa, and I was born and raised here in Oregon, and I'm a proud Oregonian. I have worked in the community for the past 10 years, and I also want a safe and beautiful, precious Oregonian that it is, right? But I do oppose 4002. I grew up in poverty, and as a woman of color, I luckily got through without a record or anything that prevented me from being my self-sufficient self with a job, with my housing, where my brother was not as lucky. I mistakenly we did get into drugs and various situations, and there was a time I called the cops on my brother with that incarceration mentality. That did not, our first reason is growing up the way we did, that was our choice to escape. But luckily, we both didn't, I'm barely getting mental health now, and whereas we didn't have that when we were young. So instead, I was the one who luckily am now without a record and I'm able to have everything where he isn't. So I'm using my sick days, my finances, and my self-sufficiency to support him, where I could have used the aid of the state for support and all the programs you could have. So we forget that at the same time that 110 was implemented, the whole world was upside down and inside out. We were going through a pandemic. So to blame everything just on 110 when we didn't even properly fund it, what if we did fund folks and the programs we needed and the ones my brother needed? What happens when we don't first take care of that childhood trauma, and then we put them and incarcerate them so that they are now re-traumatized with more traumas, and then we just want to keep the cycle and keep folks in jail? Or do we want to provide the care that is needed?
Thank you. For those online, I think the remaining people are with us remotely, so I'm going to work through that list. We have Lee Kovke. Sorry, Lee, about that. I don't even think I was close. Lee, welcome.
Thank you, co-chairs Lieber and Kropf, members of the committee. My name is Lee Wichocki. I'm a public defender in Portland, and I'm here to share some on-the-ground numbers that explain why this bill won't achieve the stated public safety goals. 2,787 is the number of unrepresented people statewide. 173 of them are in jail. These numbers will grow if you create a new class of accused persons who need attorneys. 3 to 4 months is the average wait time to find a residential treatment bed for our clients. The delay is longer for clients with a mental health problem on top of addiction, which is many of our clients. You'll increase these delays even further if you try to force a new population to the already limited number of treatment beds. 3 to 6 months, that's the current wait time for the state crime lab to test material for the presence of drugs so the evidence can be used in court. You'll increase these delays if you create a new class of cases awaiting scientific testing for use in prosecution. 1,173 is the number of clients my firm represents who've been charged with crimes, but 1 is the number of social workers my firm has to serve those clients, most of whom need a social worker to navigate the complex patchwork of scarce housing and addiction resources. I hope you plan to increase the number of social workers in my firm from 1 to anything higher than 1 if you do support this bill. 3 is the number of people who resigned from my firm since the Public Defense Reform Bill passed last year. That's an improvement over past years, but some of my colleagues more a response to a threat, the threat of a ballot initiative based on a dubious poll, and a response that ignores what we learned from the failed war on drugs. You cannot arrest, prosecute, and imprison your way out of addiction. Thank you.
Thank you, Lee. Rebecca Menda. Rebecca, are you with us?
Yes, I'm here.
Great. Go ahead.
Okay. Chairs Lieber, Krupp, members of the committee, my name is Rebecca Menda. I'm a defense-based social worker in opposition of HB 4002. I'm the only social worker in the second largest public defense firm in Oregon. I've spent 10 years dedicated to helping increase the quality of life for some of the most vulnerable, high-needs members of the community. I won't speak for all providers, but I can express how much of myself I have and continue to sacrifice to do this work. I love the work that I do, and I don't say this for your pity, but to share my concern about how this will impact already unmanageable workloads and the ability to serve our clients. Cascadia Health is the largest mental health provider in the state, and as of today, their website lists 160 open positions. Programs across the board are severely understaffed, largely related to already saturated caseloads and burnout from a lack of resources. Even with Measure 110 and the existing services, it can still take months to get someone a bed in residential treatment. This timeline does not even reflect the experience of those barriers to treatment, such as severe and persistent mental illness, or SPMI, diagnoses on their record. Rates of SPMI and inaccurate SPMI diagnoses are high among populations who receive inconsistent care. An SPMI diagnosis in and of itself is enough to get someone denied by the majority of state-accredited inpatient drug programs because they simply do not have qualified mental health professionals on staff to provide the necessary level of care. Treatment programs also deny those who are under the influence, and without access to detox support before treatment, we further narrow the options. These are barriers that are often overlooked when we think about treatment, but the ones of us that are on the front lines every day see this. When I think about how diligently I have to work to access a treatment bed for one person, it's impossible to believe that police will have the capacity or put this amount of effort and won't swiftly be sending people to jail. It'll quickly become another tool used to marginalize Black and Brown communities and perpetuate systemic racism. If I thought that jail would save lives and improve the community, I would be on board with my full support. But I know that this is not true, and I fear for the impact to come if this bill is passed. Thank you.
Thank you. Mallory Maloney.
Co-Chair Lieber, Co-Chair Kropp, and members of the committee, my name is Mallory Maloney, and I'm a staff attorney from the Oregon Justice Resource Center's Fair Law Project. I'm here in opposition to House Bill 4002, and specifically, I'm again urging you not to bring back Boyd deliveries. The Oregon Justice Resource Center worked with a research scientist to analyze a representative sample of Boyd cases spanning 3 decades, and our findings were clear. Boyd disparately affects Black and Latino Oregonians. Compared to white people, Black people were nearly 5 times as likely to be convicted of Boyd deliveries, while Latino people were twice as likely to be convicted. And tonight, you've heard from the CJC that racial disparities will persist. No fix to the current delivery statute is needed. As the law stands, people who are dealing drugs can be prosecuted for delivery. People who have drugs that have been repackaged into multiple baggies can be prosecuted for manufacture. People who are caught with large amounts of drugs can be prosecuted for possession of substantial quantities, which carries a greater penalty than a typical delivery. People who are dealing but are not caught in the act can be charged with possession as a commercial drug offense, which again carries a greater penalty than a typical delivery. Law enforcement agencies have the tools to investigate drug offenses, and district attorneys have the tools to prosecute them. Bringing back Boyd won't change this reality, but it will harm countless more Oregonians. Boyd allows for sweeping prosecutorial discretion, and we know from our review that that results in staggering racial disparities and unfair outcomes for people who are not actually selling drugs or who are doing so only to support an addiction. We also know from decades of fallout from the war on drugs that incarcerating people who possess drugs, people experiencing addiction, not only fails to keep our communities safe, it disproportionately harms Black and Brown people. We urge the legislature to focus on treatment and social services over needlessly and recklessly expanding the scope of delivery prosecutions. Thank you.
Thank you. Brittany Rainey.
Safest communities don't have the most police or jails, but the most amount of access to resources. This bill fails to do this. The members of the committee, I'm asking you to use your critical thinking skills to deconstruct the rugged individualism bootstrap bullshit we have all internalized and consider the intentional barriers you are now building into our communities. If HB 4002 passes, it shows us that we are disposable, we don't matter, it's our own fault, we are in this position, and that people with no lived experience are not the experts in our lives. Based on the prior public hearings, this legislation is showing that you listen to the voices that fit your own narrative. We are also your constituents. Our voice matters, not just the ones that fit within your own moral compass. I invite you to do the hard thing, which is shy away from this Band-Aid approach, this lazy approach, and do not pass HB 4002. We need you to do better.
Thank you. Do we have Tara Hurst with us?
Hey, everybody. Chairs Lieber and Kropp, members of the committee. For the record, my name is Tara Hurst. I'm the Executive Director of the Health Justice Recovery Alliance and a person in long-term recovery. I'm here to speak in opposition of House Bill 4002 and all the related amendments. This has been a long and rough night, so I appreciate you all hanging in there. This bill is a continuation of the state's failure to address our addiction and housing crisis. State leaders charged by the voters to implement Measure 110 into place have failed to implement it, which delayed access to treatment at a time when fentanyl began killing our communities in record numbers. There wasn't enough detox, treatment, housing, outreach, harm reduction available before the influx of fentanyl, and that need only intensified, and we know we still don't have these services, enough of these services. 110 as a policy is not a failure. The failure lies with state leadership. Measure 110 went into effect at the same time as the pandemic, fentanyl hitting Oregon, and a 23% increase in homelessness. Correlation is not causation. If you were truly trying to solve the addiction crisis, you would have created a policy based on what the local and national researchers told us in Salem at the beginning of the year, which is that there is no evidence that Measure 110 was responsible for our state's tragic upsurge in fatal overdoses. It did not cause the uptick in crime, houselessness, or drug use, which would mean that decriminalization did not cause the issues that our communities are facing, and criminalization will not solve our problems. We've seen from our work in the first 6 Portland Police Bureau and provider pilots that 99 people have been connected to care, and 53 of those were connected to services that same day. Police and peers were able to do this without criminalization. They didn't need PCS. A true treatment-first approach would be to invest the $500 million that OHA reports is needed to fill the gap in services. HB 4002 will only deepen the cycle of despair, and people will die because of this bill. Thank you.
Thank you. Justin Rosas. Justin, are you with us? Do we have Jesse Merrithew?
I'm here.
Welcome, Jesse.
Thank you. My name is Jesse Merrithew, and I'm a civil rights lawyer. And many of my clients are people who are incarcerated, many of whom have received poor or terrible health care in jails and in prisons. And I'm here in opposition to House Bill 4002. In order to understand my opposition, you have to understand 2 basic facts that are undeniable. The first fact is that a jail cell is not a safe place for someone in the throes of substance abuse. And the second fact is that there are no treatment beds available for those who want them. So while you can use whatever language you want in order to dress up what you're doing, the fact is what you're choosing to do is to place addicts in jail. And in doing so, you're going to make the same mistake that Measure 110 was criticized for making, which is to decriminalize without having the money out the door to make those treatment beds available. The difference now is that instead of leaving people on the street to suffer in public, you're going to leave people in jail cells to suffer. But they'll be out of sight and out of mind, which is the only goal that seems to be accomplished with this legislation, because people are still going to die. They're just going to die in jail cells instead of on a street corner. A jail cell is a place where their friends cannot administer Narcan or call 911 for them. A jail cell is the only place in America where you can be lawfully cut off from our emergency care network, and where you're within the jail and in the community. This bill is certain to exacerbate both of those problems, and it is going to kill people, but they'll die out of sight and out of mind.
Thank you. Do we have Ariel Hayes? Do we have Monta Knudsen? Monta? Do we have Chris O'Connor?
Yes, I'm here.
Welcome.
Thank you, co-chairs Lieber and Croft and members of the committee. I'm Chris O'Connor, a public defender for over 20 years. In a few years or a few decades from now, someone's going to be looking at the history of this bill and listen to this testimony from tonight. Maybe it's an appellate clerk researching the constitutionality of the statute, or maybe a legislature in the 2030s doing budget work on why Oregon needed a few more prisons. Or maybe it'll be a poli-sci PhD student writing a dissertation about the way the legislature fell prey to a grift by law enforcement and ended up seriously hurting the Oregon court system and Oregonians. To those future researchers, I say hello and ask them to note that me and many others here in opposition tonight are saying, quote, "We told you so." You can put that in your dissertation. I've been the attorney in thousands of cases involving probation and probation violation cases. For years, I've trained other attorneys on probation matters and exclusively worked on probation violation matters. I could talk about the specifics or take questions about the practical effects of this on Oregon's probation system and the county I'm most familiar with, Multnomah. But I'm worried you don't know the details of the current probation system and court capacity crisis. So let's just get to the main issue I can address based on my years of experience, the overly complex and ineffective probation part of this bill. There's no county probation agency or circuit court in Oregon that can handle the hundreds of new cases that will come from this. Rulemaking, forms, procedural stuff alone will take years to sort out. County jails are going to have to create positions just to do to track the bizarre time served and treatments, the equivalent of credit and time served in the jail after a revocation, but not before a revocation, et cetera, et cetera. It's a mess. Oregonians in one county are going to get treated totally different than Oregonians in another county, and the stresses are just endless. I can't see a situation in Multnomah County where someone could go into jail on day one, get an ASAM evaluation from a probation department, get on a waiting list for treatment, get accepted on that waiting list, and get released to treatment before a 30-day sanction is over. I'd be surprised if they could do that in 180 days. These are fake promises about treatment and early release. They're just cruel. They're covering up what the real goals are, which seems to be law enforcement's chance to return to search and seizing people at will and simply getting rid of the undesirables. We already have a system where pending charge cases are getting dismissed every day in our courts when the state can't proceed because there's no attorneys, or they lose witnesses after months and months of backlogs. Adding many probations and hundreds of probation cases a year, most of which will need counsel as well, will only result in more dismissals of the real, quote unquote, real criminal cases. So again, to that future historian researcher, please know they knew it wouldn't work. Everyone with real experience in these type of cases told them it wouldn't work. And if you're looking at the reason that overdoses, family separation, and mass incarceration in Oregon increased, quality of life for Oregonians, particularly communities of color, decreased, and racial disparities increased. And if you're wondering why the criminal court and public defense crisis of the 2020s accelerated, it was because of this. You found it. This is the reason we tried to warn them.
Great.
Thank you.
Thank you, Chris. Alicia Burms. Alicia, are you with us?
I am.
Welcome.
Well, thank you. Thank you, co-chairs Lieber and Croft. I am here this evening representing the Beaverton Area Chamber of Commerce and our more than 550 members. I am here in support of House Bill 4002. I'm certain you're all aware of the individual that was incinerated in our downtown not 3 weeks ago. Our system has failed him. I'm certain you're aware of our library that has drug dealers out in front of it trying to sell drugs to students. The current iteration of Measure 110 fails to acknowledge the complex nature of drug addictions. It is not working. Individuals grappling with addiction require comprehensive and nuanced interventions, as the mere availability of treatment options does not guarantee their active pursuit. Understanding the inherent challenges associated with addiction is crucial in developing policies that genuinely contribute to the well-being of affected individuals. Equally pressing is the need to empower our law enforcement agencies with the tools necessary to maintain public safety. Open-air drug use, regardless of its legal status for personal consumption, poses significant challenges to community well-being. While our police force can effectively prevent public alcohol consumption, the constraints imposed by Measure 110 limit their ability to address other forms of drug-related activities. We advocate for the exploration of alternative solutions that you're proposing here in House Bill 4002. The broader landscape of our community is marked by critical issues, including shortage of law enforcement personnel, a growing challenge of homelessness due to the scarcity of affordable housing, and a concerning trend of some district attorneys dismissing property crimes as victimless. Additionally, the closure of mental health facilities has led to a misguided reliance on incarceration for the mentally ill. We urge you to consider these systemic challenges and work towards comprehensive solutions that address the root causes rather than perpetuating a cycle of inaction. We appreciate your dedication to public service and your commitment to fostering a safe and prosperous community. Thank you for your attention to this matter, and we look forward to the positive changes that this thoughtful legislation can bring.
Thank you. Brian Martinek. Brian, you with us?
Yes.
Welcome.
Thank you. Co-chairs in committee, over the years since we lost our son Taylor, we've met with many other Oregonians that have been directly affected by the tragedy of the drug abuse epidemic in Oregon. I personally know young people who have died from unknowingly taking a fake fentanyl pill and their parents. I work with men and women who struggle with addiction even more than they did before because of the unfettered availability, that have seen the collateral damage that our communities have endured as a result. I have been saddened, dismayed, and frustrated at the seeming lack of a genuine concern and inaction that has been common response to this crisis. I did not and do not support Measure 110 for all of the predictable reasons that have played out over the past several years since its passing. I believe that the good people of Oregon were misled, lied to, and literally sold a bill of goods when they passed ballot Measure 110. Salespeople were members and supporters of an out-of-state funded organization known as the Drug Policy Alliance, whose agenda is to legalize drugs everywhere in America. This organization helped fund the campaign of politicians who would support their agenda in Oregon to create a utopian drug law-free state. The response to this issue has been partisan on both sides of the aisle when it should only be bipartisan. I strongly believe most people would not have voted for such a treacherous law had they known what we know now. Over 70% of Oregonians now hold on the matter for Measure 110. I'm respectfully demanding that you do the right thing, act, quit ignoring the obvious, and support passing House Bill 4002 with -24 amendments. Support recriminalizing hard drugs with up to 6 months in jail or mandatory supervised drug treatment. Support to replace voluntary drug treatment with required evidence-based treatment as an alternative to jail. Support giving local governments the tools to ban the use of drugs in public, and police and prosecutors stronger tools to go after the preying drug dealers and traffickers. The fact is that House Bill 4002 with the amendments are backed by law enforcement, cities, counties, local businesses, Democrats, Republicans, and 73% of Oregonians.
Great. Thank you,
Thank
Brian.
you.
Do we have Alicia Montgomery here? Good evening.
Good evening, co-chairs and committee members. Thank you for listening tonight. My name is Alicia LeDuc Montgomery. I'm the litigation manager for ACLU of Oregon. I also maintain a private civil rights practice throughout mostly rural Oregon. I'm here opposing House Bill 4002 and the amendments. To echo many of the other comments, it will result in more people in jail, and it will result in more people dying in jail. It will not necessarily result in many more people being helped into treatment. It may result in some deflection programs in some places where some law enforcement may choose not to go as hard on folks, or some prosecutors may choose not to go as hard on folks. But it absolutely will empower those jurisdictions, law enforcement, and DAs that want to make people's lives more difficult and put them more at risk. We heard tonight about the Medford Livability Team, law enforcement helping connect people with resources. So I thought I'd expound a little bit about the Medford Livability Team. It was created in 2019 and was billed as the friendly police force to interact with homeless and addicted folks and connect them with resources. Enforcement is not always the answer, is what the sergeant was quoted as saying. In fact, since it was created, the prosecutions in the Medford City Attorney's Office have increased more than 2,000 from the 2017 levels. In 2022, it went from 2,100 prosecutions to over 4,000. That has been largely attributed to the livability team aggressively prosecuting homeless and addicted and at-risk people. And in fact, they have prosecuted folks so vigorously that the deputy city attorney and both assistant attorneys have quit, citing the caseload is just untenable. The livability team, who is supposed to be the front line of alternative deflection type services for these folks, is so rough they are causing city attorneys to quit. I also represent the estate of people who have died in jails because they were not given detox medication. This is real, it will kill more people, and so I would ask Representative Mannix another hypothetical.
Do I get to answer? No.
How many people is the state of
Alicia.
Oregon going to kill with this legislation?
Thank you for being here tonight. Members, we said that we would take up legislator testimony at this point. I will say this, I would ask, one, legislators, thank you for your understanding that we were going to get through the public testimony first and prioritize that. I would ask you to be mindful of the time limit and that you have other opportunities to present your views in public manners. We still have 7 people left to testify. We will get through all of those 7 people today before we leave this room. Great.
Yeah.
Thank you so much. Fumi Soy? Sorry. Fumi, are you with us? No, that's not even. Oh, there we go.
Oh, right there.
Welcome.
Hi, can you hear me?
Yes, we can. Go ahead.
My name is Fumi Tosu. I'm the director of Dandelion House in Clackamas County. We're part of the Catholic Worker Movement, which is a national faith-based network that has been serving our unhoused neighbors for 90 years. I'm also the vice president of the board for the ACLU of Oregon. Many tonight have said that the status quo is not working, and I agree. But the reason it's not working isn't because the police don't have the authority to arrest drug users. The status quo is not working because there aren't enough treatment beds available. The status quo is not working because there isn't enough affordable housing, starting a cycle of homelessness, despair, and addiction. If one of your children fell into addiction, would you think, let me call the police, they'll handle it? So I have to wonder, whose interests are we serving with this proposed law? Because it's not the interest of those living the nightmare of drug addiction, homelessness, and despair. It's not the interest of the Black and Brown community, whom your own projection says will be disproportionately incarcerated. As a Catholic, I believe that the measure of a society is how we treat our most vulnerable members. An addict is a patient, not a criminal. Let's not become the society that fails to provide adequate affordable housing, fails to provide accessible, effective, and plentiful treatment programs, and then blames the very people we've failed by throwing them in jail. This crisis is a result of our own failure to create a society where everyone's basic needs are taken care of. The addiction epidemic is a public health crisis. It's pure magical thinking to imagine that an already overburdened criminal justice system can adequately deal with a public health crisis. Deflection only works if there are programs to deflect people into, and we know that there aren't enough treatment programs as it is. To recriminalize minor drug possession, then pretend it is a compassionate approach by peppering the bill with the word deflection is disingenuous. Have you noticed that the Black and brown Oregonians who have spoken today are all against this bill? So how committed are you to undoing racism? When it comes down to it, whose voice will you listen to? Let's invest in compassion, not cruelty, treatment, not jail. Thank you.
Thank you. Professor Michael Millard. Professor, are you with us?
I am, thank you.
Great, welcome.
Yes, my name is Mike Millard. I'm a legislative co-chair of the Oregon Society of Health System Pharmacists. OSHP is supporting a very narrow part of the bill. This is sections 6 through 8 on page 16 or 17 of the bill. I'd like to congratulate co-chair Lieber and co-chair Krupp and the committee for their perseverance this evening on this very important issue. I'm going to speak to a very specific area, which is the section on pharmacists prescribing and dispensing of the opioid use of medication refills. Allowing pharmacists to collaborate and assist in medication-assisted treatment of opioid use disorder would be an important part of improving the care and quality of both the life of the patient and the community. And access to these medications in community and health system pharmacies throughout the state would undoubtedly assist some patients to continue their treatment in any unusual or emergency situation. But I'm here to sort of manage your expectations about the impact of this very limited bill. And just to let you know, the cost to acquire a DEA registration to prescribe a buprenorphine refill is $888 plus the education attendant to gain the competency and the credential necessary to do the prescribing and to meet the requirements of the bill. The definition of what an early refill is a little bit worrisome. It's difficult to know exactly how that would be interpreted by the Board of Pharmacy. And it seems like if the committee is envisioning all community pharmacies being an access for these patients, we just wanted to point out to you that it's probably unlikely that this would be widely adopted by the profession. I've left it with my testimony some. California has adopted wide authority for pharmacists to participate in a more collaborative manner with physicians to help modify and provide this medication in a collaborative drug therapy arrangement. Won't talk about it now, but it's something for you to consider. That might extend the resources that are going to be necessary to provide care for these patients. OSHP supports anything that would expand care for these patients, and so we support these sections of the bill and support House Bill 4002 as a result. But we just want to let you know that it may not be as impactful as you might hope. Thank you.
Thank you. Do we have Jay Amici with us? What?
Yes, I'm here.
Welcome.
Hello, co-chairs and members of the committee. My name is Jay Mechi, and I'm the Reimagining Community Safety Manager for Unite Oregon. I'm also a volunteer at the Drug and Alcohol Counseling Hotline, and I'm advocating for compassionate, evidence-based responses to Oregon's addiction crisis. As such, I strongly oppose House Bill 4002, as this bill represents a significant step backwards in our collective efforts to address substance use disorder as a public health issue rather than a criminal one. Recriminalizing possession would exacerbate rather than solve the existing addiction crisis. History has shown us through the failed war on drugs that criminalization does not deter drug use and only increases incarceration rates, disproportionately affecting communities of color and deepening socioeconomic disparities. This bill abandons a science-based perspective on addiction, favoring punitive measures that lead to more suffering, particularly amongst the most vulnerable Oregonians. And Representative Mannix, I have to say that it's actually obscene to try to spin the disparate impacts of the criminal legal system as something that Black people could benefit from. Decades of punitive enforcement-focused policies have had devastating impacts on the Black community. To imply that arresting more people will somehow save Black lives is actually sick. It's racist and it mirrors the rhetoric of those who sought to justify slavery by claiming that Black people benefited from it because we couldn't handle or don't deserve freedom. OHSU released a study that showed opioid disorder overdose risk is 10 times greater for those recently released from jail. The Oregon Health Authority's new overdose prevention data dashboard shows an increase in drug overdose deaths from 2000 to 2001, with the highest rates of death being among Oregon's Black and African American communities. Death rates by other racial groups that were also affected were American Indian, Native Alaskan residents as well had high rates. So investing in housing, crisis outreach, and rapid access to care has been proven to be more effective in addressing the root causes of addiction. These solutions offer real hope and healing rather than perpetuating cycles of despair. HB 4002 not only misallocates taxpayer dollars, but it also ignores the broader systemic issues at play, such as homelessness, poverty, which are inextricably linked to substance use disorder. Thank you.
Thank you. Do we have Stick Crosby with us?
Yes, I am here.
Great.
Thank you for hi, I'm Stick Crosby, Jackson County resident. Thank you, Chairs Lieber and Crow. Really, I found much of the testimony tonight interesting to hear and from the different places that it was coming from, but I also wanted to kind of echo everybody's statement around accountability. I do not support criminalization in any way. And really that's because as you've heard here, all the different ways that we have not implemented the services over the past, I think about 3 years now, since this bill has been active and the bottlenecks in the OHA. I've given some testimony previously on this. I hope you take a look at that. I've been in managed care contracting for about 7 years. But one thing that's really important to me, I was talking about accountability, and as I can't really, everything that's been said tonight has already been said, and it's going to be kind of a waste of time. But one thing is there's been a huge amount of misinformation related to Oregon and opioid deaths. So what I have done is to set the record straight for tonight. I've gone to the CDC dashboard, and I'm going to go ahead and start reading off the states that are leading on opioid deaths so that we can see that Oregon is not number one, and that Measure 110 did not do this. So here we go. West Virginia, Tennessee, Louisiana, Kentucky, Delaware, New Mexico, Ohio, Maine, Pennsylvania, Indiana, Maryland, South Carolina, Connecticut, Vermont, Rhode Island, North Carolina, Arizona, Florida, Massachusetts, Missouri, Alaska, New Jersey, New Hampshire, Wisconsin, Michigan, Colorado, Virginia, Alabama, Nevada, Illinois, New York, Mississippi, Washington, Oregon, at 26.8 deaths per 100,000 individuals. So I just really want to be clear here that there's a lot of stuff thrown out, and that is a fact and something that we should think about in the way that you do this. And I really hope you don't focus on criminalization. You start funding these services, especially co-occurring disorders in our communities, and especially for this population that everybody's talking about with the homelessness, because they are Medicaid eligible and there's funding within that program. It's not a lot, but it's there to help support these folks. Thank you for your time tonight. I really appreciate you listening to all of us. Have a great night.
Thank you, Stick. Do we have John H. with us? John?
Yeah, can you hear me?
We can. Go ahead.
Cool. My name is John. I'm in long-term recovery. Been in recovery for about 17 years and a former addictions counselor. It is not time to scapegoat ballot Measure 110 just because it's politically expedient or to appease wealthy reactionary NIMBYs. If you keep misdiagnosing the problem, you will provide the wrong treatment. People in recovery and advocates have been sounding the alarm bells here in Oregon for 6+ years because we have ranked dead last in access to treatment and have had some of the highest rates of have had some of the highest rates of substance abuse in the U.S. We have made very little progress due to the lack of expansion of treatment, detox, and recovery services. Measure 110 has only improved the accessibility of treatment and recovery services, but there's still wait lists everywhere. To make things worse, we experienced a pandemic that impacted every area of our lives, and fentanyl started flooding our drug market in the region in 2020. Make no mistake, fentanyl is the result of the war on drugs. It's cheaper, more powerful, and harder to detect. Fentanyl was a response to drug enforcement and the need to evade that detection. Just like people switched to heroin when oxys were reformulated to prevent smoking, snorting, and shooting, and P2P meth was formulated when over-the-counter ephedrine was banned. Same thing. You will never enforce our way out of this problem. We need 3,000 more treatment beds added to our existing 5,000. We've been saying this for years and you haven't listened. Now you're putting all this effort into the wrong solutions. The vast majority of those that sell drugs are addicts. You are just going to increase penalties for selling, which will have no impact on drug use and increase incarceration. Using emotionally charged words like traffickers instead of sellers isn't fooling me, and arresting them will save 0 lives because you aren't going to put a dent in the drug market. It's not going anywhere. Between 2012 and 2016, the U.S. had a 172% increase in fentanyl overdose deaths in the country, and the country was mostly silent. Fentanyl has now moved from the East Coast to almost fully replace the heroin market in our region. The same overdose spike occurred on the East Coast. From January 2016 to January 2017, we saw a 380% increase in fentanyl deaths in D.C., 217% increase in Maryland, 147% in Virginia. The list could go on. So really, we need to look at what is the cause, and anybody that knows, we need to look at the causal relationships, not correlation. If you don't know what that means, if you don't have experience with addiction or have suffered from addiction, you really have no place trying to find solutions to this problem. You need to talk to people that know what they're doing. Thank you.
Thank you. Scott Moore. Scott, there you go.
Hi, I am. Okay. Hi. Chairs Lieber and Croft, members of the committee. For the record, my name is Scott Moore. I am the Community Affairs Officer at Quest Center for Integrative Health, a physical and behavioral health center located in Portland. Quest Center is a proud member of the Indigeneity Behavioral Health Resource Network in Multnomah County, funded by Measure 110. I testify in opposition to HB 4002 and its related amendments. Measure 110 was passed by the Oregon voters to remedy Oregon's failure to effectively plan and fund a system of behavioral health care necessary to support the state's thriving economy and population over the past several decades. This failure has had a devastating impact on marginalized populations across the state, including rural communities in need of healthcare resources. Measure 110 has provided unique opportunities for culturally specific treatment to individuals most often discriminated against and oppressed by Oregon's institutions biased towards the white heteronormative populace. Quest Center and our indigeneity burn partners have stood up incredible and highly effective culturally responsive programs to appropriately address the needs of these vulnerable populations. At Quest, we now have LINK, Living with Intention and Knowledge, a harm reduction-based outpatient substance use treatment program, which acknowledges the spectrum of substance use. In partnership with the Miracles Club of Portland, the Resilience Initiative is a unique addiction treatment and pain management program specifically focused on serving the African American population community. HB 4002 opens the door to eroding the promise of Measure 110 to fund and address addiction as a medical condition by creating cash-starved amendments unfunded by this bill. Addiction recovery programs such as LINK and TRI are directly threatened by 4002 in a state that has continuously chosen law enforcement over health care to treat addiction. Burn providers need continued support from the legislature by solidifying existing burn funding. Oregonians need the legislature to act now to create new long-term sustainable funding streams specifically designed to address the fentanyl crisis, deeply impacting Oregon cities and counties by providing appropriate supportive housing, treatment beds, and culturally appropriate services equally available across the state. 4002 fails to protect the funding Oregonians deem necessary to treat addiction fairly, equitably, and without the politics that prevented the legislature from decades of inaction. Thank you.
Thank you, Scott. New Hammond, Eden?
Yes, I'm here.
Great. Go ahead.
All right. Co-chairs Lieber and Croft and members of the committee. For the record, my name is Nuhamin Aiden, Deputy Director at Unite Oregon, a membership organization led by Black, Indigenous, people of color, immigrants and refugees, rural communities, and people experiencing poverty. I'm here in opposition to House Bill 4002 and all related amendments. Criminalization inflicted decades of government harm and violence on Black and Brown communities. In my previous testimony, I shared with you such story of my little brother who would still be alive today if we invested in resources to care for all Oregonians instead of jailing them. This committee pledged to work with impacted communities and to work on this solution with us at the table. Yet, under House Bill 4002, more Black, Brown, and Indigenous people will be convicted, get criminal records, and be incarcerated, which will lead to higher levels of drug addiction, overdose deaths, poverty, and houselessness. How can you say we were at the table when we were the ones on the menu? House Bill 4002 will also dramatically increase the burden on the public defense system that is already in crisis, and you heard on that quite a bit today. I urge you to vote no on this deeply flawed legislation, and don't abandon our racial justice values. Don't abandon the goal of a public health approach to addiction. Please don't support the criminalization provisions of House Bill 4002. While I'm grateful for this opportunity to share my opposition to this bill, I am disappointed that the lawmakers aren't providing more time for Oregonians to read the legislation and make their voices heard. The legislature's short session is just 1 month long. This is a crisis decades in the making that deserves ample time for input and analysis. Too many lives are at stake to rush this 100+ page bill through without room for sufficient public input. Thank you.
Thank you. Members, I think that concludes all the public testimony. Is there anybody online or here in person that thinks they signed up to testify that has not testified yet? Great. I appreciate your understanding that we're going to get to the public testimony, and then I'd also appreciate your understanding that staff members cannot leave until we conclude all the testimony. So with that, Senator Brock Smith, Representative Boyce, and Representative Deal, if you want to come on up. Just look her right in the face.
I would totally just leave if I wanted to.
Co-chairs Lieber, co-chair Krupp, for your record, State Senator David Brock Smith, representing Coos, Curry, and Douglas counties in Southwest Oregon, District 1. I want to thank you for, and my colleagues here, for taking the time to listen to our testimony and all of the public's testimony that we have heard for many months, actually, about this issue and the experts. And I really want to thank you all for the work that you have done in not only working with stakeholders and groups, but also our law enforcement professionals, such as the Oregon State Sheriff's Association, the Oregon Chiefs of Police, the Oregon District Attorneys, the League of Oregon Cities, and the Association of Oregon Counties, and that work and culmination of the -24 Amendment. I do want to shift, however, to the -4 Amendment for your consideration to be included in the bill. We have a situation where we do, and we all know we have a border crisis, and we all know that we have fentanyl coming in from across that border, and it is killing Oregonians. And so we need to make sure that there are penalties associated with illegals that are in Oregon and selling and or dealing and or manufacturing fentanyl. And that is what the -4 would do, is it would contact the U.S. Immigration and Customs Enforcement Agency so that we can make sure that that is the case. And then, as you know, colleagues, I'm also a member of the Ways and Means Public Safety Subcommittee and have the privilege to serve with you on that committee here in the legislature, as well as the Council of State Governments West co-chair of public safety in their committee. And so we have heard lots of testimony on the issue regarding not having enough public defenders. You heard the chair of the Oregon Public Defense Commission say that. And so I direct you to the -39 Amendment, which briefly just has our trial attorneys of this state or anyone that has that's not employed by a public body but as a member of the Oregon State Bar, would have the Oregon Public Defense Commission provide training for criminal defense law that prepares trial attorneys to satisfy the requirements. And then that would have the Oregon Bar shall require a trial attorney in this state to provide at least 120 hours of public defense services on or before December 31st of 2027. That would assist in them helping with this reform and moving forward, and assist in our public defense shortfall with their generosity in helping that situation. And so I encourage you to look at the -4 to deal with the immigration issue and the sale of illegal drugs, and the -39 to assist in the public defense services that we desperately need today and will desperately need in the future. Thank you.
Thank you. Go ahead.
Co-chairs Representative Croft and Senator Steiner, distinguished committee. Well, I've testified and offered some public comments over the years. I don't think there's anything more important than what we're discussing. I want to give a huge shout out to all of you for staying late, working hard. I'm not surprised, but this is a huge ask, and thanks for giving us the time right now. I want to send out a shout out for law enforcement. Sometimes people forget that they've been through 3 very, very tough years. They're still trying to recover. Recruiting is down. Talk to our state police. We all know that. Oregon has a drug addiction crisis, which has brought us an explosion of deaths and addictions and crime and overdoses. Our state has the highest rate of increase. Someone said earlier that Oregon is not 48th or not 49th, but it rates up there very high. As Senator Steiner said earlier, 5 deaths, overdoses per day. It's hard to wrap your brain around that, how serious that is. Sometimes visuals of overdose victims lying, literally dying in the streets, tragically seem to no longer shock. We all need reminded the drug and addictions crisis is a statewide issue, and Oregon's rural and coastal communities are confronted with a steep supply imbalance of our inpatient care. Drug addiction and needed treatment are often thought of as issues facing urban and large metro communities only, but the reality is rural Oregonians suffer from addiction at similar rates as do other areas. Our citizens generally do not have access to the types of inpatient facilities necessary to cure our state's addiction crisis. Without those services, we cannot fulfill the critical needs. We must work together to get drug-addicted individuals off the streets and into rehabilitation for their sakes and ours. The -34 amendment drafted by Representative Mannix is a welcome start to the conversation around inpatient treatment access and care in rural communities. We must provide our cities and counties, both urban and rural, the resources to provide those much needed drug treatment services. I ask for your support on the amendments 34 for House Bill 4002 as one important piece in our current drug use epidemic. Thank you very much.
Thank you.
Co-Chair Lieber, Co-Chair Kropp, and committee members, my name is Ed Deal, State Representative for House District 17, East Salem, through the majestic Santiam Canyon. Thank you for the opportunity to speak on the -24 amendment to House Bill 4002. I believe we all have the same goals: to protect public safety and to get people clean and leading productive lives. And with this in mind, I'm recommending 3 amendments to fix some of the shortcomings of the -24 amendment. These amendments are in the process of being drafted and are not yet posted. First and foremost, we need accountability with how Oregonians' hard-earned tax dollars are spent on treatment and recovery services. And unfortunately, I do not believe that we have that today. Our first amendment would transfer the control of ballot measure 110 funding out of the Oregon Health Authority and away from the Oversight and Accountability Council. Control of this funding would be transferred to the Alcohol and Drug Policy Commission. We have a desperate need for treatment and recovery services. However, we have seen that the OAC is slow to distribute the funds, and in my opinion, they are funding the wrong services. We have numerous reports of funds being misused. The OHA is currently trying to recover funds that were apparently used to purchase homes, cars, and other fraudulent uses. A second aspect of accountability is to measure results. Our Second Amendment addresses this deficiency. Currently, there's little to no accountability for how Measure 110 money is being spent. Our amendment proposes that the state engage an impartial third-party organization that annually and objectively reviews and measures whether each nonprofit or government program that receives state money has demonstrated that they're delivering results. Finally, we need to acknowledge that we have a healthcare workforce crisis in this state. This crisis directly limits our ability to provide treatment and recovery resources to those that need it. We cannot leave this building, folks, until we have addressed the workforce crisis in this state. Our Third Amendment addresses this crisis in access to care, specifically our significant and immediate need for social workers and counselors. The task force called for in this amendment will be charged with modernizing our licensing systems, evaluate how licensing affects access to substance use treatment, and how we can improve and expedite the licensing of social workers and counselors to better address the addiction crisis. I urge you to consider making these important improvements. Oregon can't afford a half-baked solution. Thank you.
Thank you, Representative Mannix, Representative Levy, and Representative Owens, please. See ya, Greg. You're not going to stay for your colleagues?
They're your peers.
Yeah.
You're going to walk out
Greg?
on
I'm going to be the grand finale.
You know, some of us have to start at 7 a.m. in the morning here.
So do I. Welcome.
Good evening, co-chairs, members of the committee. My name is Kevin Mannix. I'm a state representative. I represent Kaiser and North Salem. Yes, I am a member of this committee, but I want you to be aware that we do have an opportunity to build on what has been done. I am not presenting to you opposition to what you have in front of you, but I am asking you to build on it with 9 amendments, mostly civil matters. A -12 amendment, which would authorize parents to seek involuntary admission of any child under the age of 18 to a treatment facility for drug rehabilitation. They'd be paying for it. Right now, they don't have the authority to do that. The -15 amendment would re-empower local government to enact local ordinances restricting public use of drugs which are unlawful under federal law. That means using drugs in a park. The -17 amendment would create the Office for Drug Prevention and Treatment to coordinate statewide programs and to evaluate the use of the Dome building right here in Salem, which could hold several hundred patients it used to as a state hospital facility, as a residential treatment facility. And we'd call for the study of that, not for the automatic doing of that. -18 amendment, you heard from Dr. Allison Myers, Myers, from Oregon State University. They're working in 6 counties. Let's enhance and support their project to accelerate the promotion of behavioral health in rural areas. The -19 amendment, have the state police study ways to expedite drug testing for criminal cases so we'll know what's really going on. The -20 amendment, I'll let someone else speak to that, that has to do with drug trafficking. The -34 amendment, we want the Department of Corrections to work to establish regional residential treatment facilities. We may decide that that should be a civil program, but there is a lack of residential treatment facilities around the state. The -35 amendment, Taylor's Law, you heard about that. A person with substance use disorder may be committed and receive treatment as to that substance use disorder, a civil matter. And the last civil matter, new hospitals providing substance use disorder treatments would not be subject to the certificate of need process. You'll hear more from me during a work session. I think these are ways to add on to what you have in front of you. Thank you.
Thank you, Representative Levy.
Thank you, co-chairs Lieber and Kropp, members of the committee. My name is Bobby Levy. I represent House District 58, Umatilla, Union, and Wallowa counties. I'm here to express my strong support for the -12 amendment, which addresses the issue of minors being involuntarily admitted to addiction treatment by their parents. As a concerned citizen and advocate for the well-being of minors struggling with addiction, I believe it is crucial to provide parents with the necessary tools to intervene in cases where their child's substance abuse poses a significant risk to their health and safety. The -12 amendment recognizes the complex nature of addiction and the challenges that minors face in seeking treatment on their own. It acknowledges that parental intervention may be necessary in situations where minors are unable or unwilling to recognize the severity of their substance abuse problem and take proactive steps to address it. Allowing parents to admit their minor children to addiction treatment provides a lifeline for families grappling with the devastating effects of substance abuse. It enables parents to take decisive action to protect their children from the harmful consequences of addiction and ensure they receive the support and treatment they desperately need. Moreover, the -12 amendment includes safeguards to prevent abuse of the admission process, ensuring that it is utilized only in cases where the minor's substance abuse poses a clear and immediate danger to their well-being. It emphasizes the importance of professional assessment and oversight to determine the most appropriate course of treatment for each individual case. The -12 advocates for a comprehensive and holistic approach to addressing addiction in minors. This amendment recognizes that addiction is a complex health issue that requires comprehensive intervention strategies, including family involvement and support. I urge you to support the -12 to House Bill 4002 as a crucial step towards addressing the growing problem of addictions among minors. By enacting this amendment, we demonstrate our commitment to providing families with the resources and support they need to help our children overcome addiction and lead healthy, fulfilling lives. Thank you.
Thank you. Representative Owens?
Thank you, co-chairs, members of the committee's colleagues. Thank you for the testimony, and thank you for taking on this challenge. This is probably the most controversial subject we'll have this session, and hopefully for sessions to come, we won't have to go there again. Maybe the staff has my PowerPoint presentation. Bad joke. Bad joke. I'm here to follow up on Dr. Allison Meyer's conversation about community conversations about mental health and OSU's role here. It is the -18 for Kevin Mannix, or it could be a line item in the community planning section of the funding bill. Listening to 5 hours or so of testimony myself tonight, one thing I've learned is we're going to need help. If we're going to ask counties to set up deflection programs with stakeholders they've never dealt with, work with community partners, law enforcement, DA, local elected officials with their own perspective, it's going to be tough. And how do we get through tough conversations as a body here? We come together with an inclusive group of stakeholders and we have conversations. OSU has a proven track record of doing this in mental health. This program has just started up. This program can be and should be utilized in our small counties and our large counties. Senator Finley and I just got off a Zoom with multiple county partners, and they're struggling with not only signing the letter of commitment, but trying to figure out how they'll do this. I know Dr. Myers can help with this, and OSU can help. They have a proven track record of providing more grant funding, integrated programs, stronger working relationships. In Malheur County specifically, the last one they did, they're still working on crisis stabilization, youth prevention, and interagency task force. And Dr. Myers did not get to that part of her testimony and asked me to include that. I hope you can consider the -18 or a small funding portion to go to OSU in the community planning section. Thank you, colleagues.
Thank you. Representative Wright and Heeb. And Representative Goodwin, did you want to, you can, either way. Great. Welcome.
Oh. I guess I'm up. All right. Good evening, Chair Kropp, Co-Chair Lever, and members of the committee. I used to be a libertarian. I was studying Portugal and the effects of decriminalizing drugs. I even traveled to D.C. to meet with Ron Paul.
Representative, can you state your name for the record, please?
Yep. All right. My name is James Heeb, House Rep, HD 51.
Great.
So I was a libertarian. I was studying about Portugal and the effects of decriminalizing drugs. I even traveled to DC, met with Ron Paul and other liberty-minded Americans. I thought decriminalization and treatment was a solution. Between 2008 and 2014, I did all I could help to my brothers make it through their addictions, taking them to rehabs in Oregon, Washington, Idaho, and Colorado. But no facilities would provide more than 2 weeks worth of treatment. Then my brother Joseph died from a fentanyl overdose. On March 5th, it'll be 10 years here soon. Then December 23rd, 2014, my brother Daniel overdosed and died. Then January 5th, 2016, I witnessed one of my best friends vomit blood till he was dead. Then in 2017, I began to advocate for mental health care and drug treatment in the state. And I watched OHA and the unions block rehab from being built. Then over the years, 2 more treatment hospital projects were killed for the same reasons, OHA and the Certificate of Need. I had some things to reevaluate since my views had drastically changed. I was incredibly naive to believe that addicts would just pursue treatment for no reason. My heart broke for these addicts who are in bondage to their addiction. I'm a compassionate person, full of empathy and love for others, but my feelings had deceived me. I realized I needed to make a change. I needed to think with a little reason and logic, not just my heart. So I registered as a Republican in order to fight bad policies that perpetually fail and are costing people their lives. I will continue to fight 7 days a week, 365 days a year for as many years as it takes. Right now, that's in support of Dash 36 Amendment, which would put a temporary pause on the requirement for the Certificate of Need and would allow some of these treatment centers to be built. Thank you.
Thank you, Representative.
Co-chairs, members of the committee, I'm Christine Goodwin, State Representative for House District 4. And I have been listening to my constituents, and I've been listening for hours of testimony in this committee. And I've listened to people from all walks of life and all perspectives about how to solve this problem. But I want to speak to my support for the Dash 20 amendment that will keep traffickers in custody until arraignment, impose mandatory bail between arraignment and trial, and make the state bear the cost of the pretrial incarceration. Earlier this month, I had the honor and the horror of spending the day with Josephine County police officers on a citizen ride-along. For 6 hours, I talked with hungry, cold, unbathed, homeless drug addicts, some incredibly young. These individuals were not just products of poor choices and family dysfunction or easily accessible drugs. They are also the product of what we've done in decriminalizing hard drugs. The opportunities Oregon has created for these individuals to continue in this death spiral is unconscionable. And now is the time for Oregon lawmakers to face the facts. And the fact is we screwed up. The fact is Oregon voters were sold a bill of goods on Measure 110, and now a majority of them have buyer's remorse. Albert Einstein said, "We cannot solve our problems with the same thinking we used when we created them." And wow, have we created some problems. Today we have the chance to change our thinking and fix some of the mess that we've created. How many lives would be saved if drug traffickers were in custody? How many children might never make that first bad decision if drug traffickers were held in custody? How many addicts would have the benefit of a clear head, even for a few days, to make a good decision and seek help if traffickers were in custody? Colleagues, please stop thinking the same way that has got us into this mess. Let's work the problem and not perpetuate it. We must keep drug traffickers in custody until arraignment. We must make a bail requirement between arraignment and trial, and we must give the counties the resources they need to hold drug traffickers in custody. We can do this, and we must do this.
Thanks.
Thank you.
Representative Wright.
Chairs Lieber and Croft and committee, thank you. It's past my bedtime, so I'll be brief.
Your name?
Having spent 31 years in public, I'm sorry?
No, go ahead.
Your name?
Representative Boomer Wright, represent District 9 on the beautiful Oregon coast. Committee, having spent 31 years in public education as a teacher, principal, and superintendent, I've come to believe that our schools are the mirror of society and knowing our children are the future. Presently, drug proliferation, drug usage, addiction so prevalent in our society is causing our children to suffer that influence. We need a life-saving pathway to ensure parents, guardians of our children, our future, can get treatment necessary for their children. In Measure 4002, there is no parental authorization to seek involuntary admission of any child under the age of 18 to a treatment facility for drug rehabilitation. Without this authorization, parents who love and know their children better than anyone cannot get their children and our future into a life-saving treatment facility as needed. For the sake of the lives of our children and our future, I implore you to include the amendment to authorize parents, guardians, the ability to seek involuntary admission of any child under the age of 18 to a life-saving treatment facility for drug rehabilitation. Thank you.
Thank you. Representative Elmer, are you with us? I thought I saw her.
She was on there. She was, yeah. And she was gonna.
Okay. I don't see her anymore. Members, before we conclude, any comments? Representative Lever?
Brian's saying.
I see Rep. Elmer. Oh, okay.
Rep. Elmer, are you here with us?
I am, thank you.
Good.
I'm up.
Yep, please.
Okay, thank you. Co-chairs, members of the committee, thank you for all of the hours and hard work you've put into this. My name is Lucetta Elmer, State Representative for District 24. I am here tonight in support of the -36, which is repealing the Certificate of Need. The Certificate of Need is a regulation that the Oregon Health Authority has in the state of Oregon to look at, to either allow or not allow hospitals, new hospitals, treatment facilities, any medical facility or expansion in our state. And right now, as you probably all know, we rank high, very, very high in how many addiction crises we have, and we rank very, very low near the bottom in how many beds we have. So to be able to repeal this would allow us to more efficiently get more beds and more treatment facilities in our state. So right now, colleagues, we stand on the brink of a really significant step forward in our commitment to addressing addiction and supporting those who are battling it. For too long, barriers have stood in the way of individuals seeking the help they need to overcome addiction. And one such barrier has been the ability of OHA to block the establishment of addiction treatment facilities within our state. By repealing this law or pausing it, we are not only removing an obstacle, but we are also sending a very powerful message of compassion and support to those struggling with addiction. Addiction, as you know, is a complex and challenging issue, and it affects individuals from all walks of life. It doesn't discriminate based on anything. So allowing addiction treatment facilities to be established more freely across our state, we are opening up avenues for recovery and healing. We are providing hope to individuals and families who have felt trapped in the cycle of addiction. We are reaffirming our commitment to treating addiction as the public health issue that it truly is, rather than stigmatizing those who are affected by it. Furthermore, by expanding access to addiction treatment services, we are taking a very proactive approach to addressing broader societal issues. Addiction not only takes a toll on individuals and families, but it also strains our healthcare system, our criminal justice system, and our whole justice system. Our communities as a whole. So by investing in prevention, treatment, and recovery support, we can mitigate these impacts and build stronger, healthier communities for everyone. I do support the -36 amendment. Thanks.
Great. Thank you. Members, anything to add before we conclude? Great. So thank you, everybody, for being here today, and thank you, everybody, for your testimony. We heard heartbreaking testimony, we heard smart testimony, we heard compassionate testimony. Some of it was opposed to what we were working on, and some of it was in support. I'm reminded tonight of not only that we have to continue to create additional pathways and access to treatment, but also a reminder of the racial disparities that have existed in our criminal justice systems and the concerns raised about these laws, about how this bill might impact brown and black communities, are real and valid. As I think about the ongoing work of this committee, we have multiple responsibilities. One, making sure the prevention efforts that we are taking on are effective and preventing further addiction, and that we are creating those additional pathways and those additional access to treatment. But also be prepared if the law that we're proposing and the deflection programs and the new way of a criminal justice system continues to have racial disparities. I'm committed to that work, and that will be at the forefront of this committee work going forward. Members, we are here again tomorrow at 5 o'clock to further discuss this bill, and I look forward to seeing everybody then. That will conclude the meeting.